Okay. Okay. Miss A filed a petition for writ of amparo claiming that she was being threatened by Mr. B, her boyfriend with whom she has a child out of wedlock named C. Miss A alleged that since she started dating someone else, Mr. B began stalking her, parking his car on the street outside her house, and watching her house until the wee hours of the morning. She thus feared for her life. Writ of amparo. Oh, parang question to nung last time. Sige. A. Uh, no. Ah, ano ba? Hindi ko alam. Hindi ako mahula. Anong sagot? No, the Supreme Court that a person is not entitled to the issuance of a writ of amparo against private individuals or entities if there is no showing of direct or indirect government participation in the violation of the aggrieved person's right to life, liberty, or security. Here, there is no showing of direct or indirect government participation in Mr. B's stalking of Ms. A. Hence, Ms. A is not entitled to a writ of amparo. Okay? And then, for B, sabi, assuming that Mr. B took away C without Miss A's knowledge and consent. What is the proper remedy for Miss A to immediately recover C's custody? So basically, ang question is, mag-ex si A at B, may anak sila, si C. Tapos nung nagkaroon na ng boyfriend si Miss A, so ngayon, ini-stalk niya ngayon yung mag-ina niya. Hanggang sa, ang tanong ngayon, paano kung kinuha ni B yung anak niya from Miss A? What is the proper remedy? Okay, ang sagot, without proper consent, the proper remedy for Miss A to immediately recover C's custody is to file a petition for writ of habeas corpus in relation to custody of minors. Under the law on special proceedings, the writ of habeas corpus extends to all cases by which the rightful custody of any person is withheld from the person entitled thereto. The writ may be used to immediately recover custody since in the calendar of cases, preference is given to habeas corpus cases. And the judge may forthwith adjourn a habeas corpus case into the court upon the return of the writ. Okay, the writ. Okay, sige. Next tayo. 2 minutes. Okay. Ms. N initiated a special proceeding for the correction of entries in the civil registry under Rule 108 of the Rules of Court before the Regional Trial Court, including only the local civil registrar therein. In her petition, Ms. N sought to change the entry in her birth certificate with respect to the date of her parents' marriage from May 22, 1992 to not married. The Office of Solicitor General opposed the petition, arguing that Miss N's parents should have been impleaded in the proceeding. Was an entry in her own birth certificate, which she intended to change. Sorry. Sabi niya, Miss N's parents should have been implemented in the proceeding. In response, Miss N argued that this was not necessary since it was an entry in her own birth certificate which she intended to change. Hence, it was a matter personal to her, and as such, the participation of her parents in the case could be dispensed with. Miss N's position correct? No. Kasi it involves the marriage of the parents. I'll try to answer this using a bar format. No, Miss N's position is not correct. Under the law, under siguro ano to, jurisprudence to. Under Rule 108, correction of entries. Oh, it is necessary to implead all relevant parties to the case. Here, Miss N's parents who were supposedly married are now being represented in her correction of entries as not having been married. This then involves the personal circumstances as well of her parents. Hence, her parents should have been impleaded and Miss N's position is incorrect. Law on special proceedings. All persons who have any interest which would be infected by the cancellation should be impleaded. Hindi pala relevant. Medyo mababaw yung sagot ko dun sa all relevant parties to the case. Dapat ang sagot is all persons who have any interest which would be affected by the cancellation. Okay? Okay, sige. Siguro bigyan naman niya yung mga 2-3 points. Pwede na ako. Masaya na ako dun. Okay? Okay? Distinguish the following. Writ of kalikasan and writ of continuing mandamus. Okay. Kahinaan ko talaga spektro. Malalaman natin ng spektro natin kahinaan, mga boy. Okay, may answer. A. Writ of kalikasan is that which is issued in recognition of the transcendental of the doctrine of transcendental importance. This is issued for any cases involving nature, recognizing that it is our duty to carry over healthy and sustainable ecology to our next generations. Yeah. Mga ganyan. It is um it is a writ which specifically um orders doing one thing for one instance. Writ of continuing mandamus on the other hand. Okay, writ of continuing on the other hand is a mandate, an order which shall uh, be sustained for generations to come. It is of continuing, it is issued to recognize that caring for the natural resources and our environment is not a one-time thing. Okay. Hindi ko alam. Nanghula na lang ako. Warrant to search WSSECD. Pag-aralan ko to eh. Diba? Pag-aralan natin to guys. Diba? Hindi ko na alam ngayon. Is that which is issued to shit, ano ba yung ano natin? Nakalimutan ko na kagad yung acronym natin. Tatlo. PRA. Hindi. Ano yun eh? Yung PRA is ano yun? Res judicata yun eh. Hindi ko maalala. Ano nga yung ano? Ang hirap. Sige nga. Ano to? Try natin. Uhulaan ko to. Mali ito. Kaya ako ng oras dun. Sana binasa ko na lang. Rate of kalikasan is distinguished from rate of continuum damus as to follows. Rate of kalikasan is directed against public or private individuals. Violate a person's right to a balanced and healthful ecology. While a right of continuum is directed against public individuals or entities who neglect the performance of a ministerial duty in connection with the enforcement or violation of an environmental law or regulation or unlawfully exclude another from the enjoyment or use of an environmental right. So yung nature, it's against public or private, while writ of continuum mandamus must be against a public official. And this is, okay, gets. As to magnitude, a writ of kalikasan is available in cases involving environmental damage of such magnitude as to prejudice lives, health, or property of inhabitants in two or more cities or provinces. Well, there is no such requirement on magnitude with respect to a writ of continuing mandamus. Okay. So, wala namang magnitude requirement sa writ of continuing mandamus. As to where filed, a petition for writ of kalikasan is filed with the Supreme Court or with any of the stations of the Court of Appeals, while a petition for writ of continuing mandamus is filed with the Regional Trial Court exercising jurisdiction over the territory where the actionable neglect or omission occurred, or with the Court of Appeals or the Supreme Court. Okay. Sige. A WSSED and a WECD are similar in that both are used by law enforcement authorities to examine computer data. Okay? By WSSECD, that is warrant to search, ano to? Warrant to search, seize, and examine computer data. Yung isa naman is warrant to examine computer data. Pinagkaiba. Kasi yung isa may search and seizure, yung isa examine lang. Okay. Sa WSSED, search and seizure,
wala pa sa possession ng court. So, kailangan pa ng warrant. Pero sa WECD, examine lang, unlawfully acquired na by the court. Okay. Yun ang pinagkaiba pala. O, di ba? At least natatandaan natin yung mga ganyan. Pagdating ng bar, di ba? Medyo meron tayong konting idea kahit paano para mambola doon sa bar. Okay. As to nature, as to magnitude, and were filed. Okay. Okay, game. 452. Yan, si bro, yan. Yan ang gusto ko, yung mga... Ayaw ko talaga ng spec pro yun. Ang unusual kasi ng spec pro questions, hindi ko alam kung paano sagutin. Okay. Mr. X filed a complaint of sum of money against his old friend Mr. Y in order to ensure that Mr. Y would not be able to file a responsive pleading and much more participate in the case. Mr. X paid off Mr. Y's counsel, Attorney C, who deliberately let the case proceed as such without his client's consent. Okay, eventually judgment was rendered on March 1 in Mr. X's favor. Okay, so na-receive ni Attorney Z on April 4, 2016. Bothered by his conscience, Attorney C brought a copy of the decision to Mr. Yon on June 1, 2016, thereby reprising the latter and causing him grief. Meanwhile, the decision became final and executory on April 19, 2016. Thereafter, Mr. Yon took steps in vindicating his rights, which culminated in August 15, 2016, when he, as represented by the new counsel, filed a petition for annulment of judgment before the Court of Appeals on the ground of extrinsic fraud. The CA dismissed the petition on the ground that Mr. Y failed to submit a satisfactory explanation as to why he directly resorted to a petition for annulment of judgment when he could have filed a petition for relief from judgment. Ang hirap naman pag di-distinguishin mo ako nito. Ano pinagkaya ba nito? Buti nandito ko na-encounter kaysa sa bar. Sagot. Petition for relief from judgment. Pag relief from judgment, hindi ko alam. Sige, bigay mo na sa akin. Give it to me. Okay, ang pinagkaiba. Ang hirap naman pag distinguish, ganito lagi kahaba yung sagot ko. Di ba pwedeng paikliin to? Awitize. Sige. Ganyan lagi kahaba sagot ko. Pagod. Pero sige, itindihin natin. Sobrang meaty ng discussion, so kailangan natin siyang ma-absorb. And then pag binalikan natin, dapat masagot na ulit natin siya. Okay, nasa yung B. Okay, sige. Difference. The ground for petition for relief from judgment are when a judgment or final order is entered or any other proceeding is thereafter taken against any party through fraud, accident, o fame. So, kapag petition for relief from judgment, yun yung fame. Okay, when a judgment or final order is rendered by any court and a party is prevented by fame from taking an appeal. Kaya ba ng 1 at 2? Judgment or final order is entered or any other proceedings thereafter taken against any party. So, pag nagkaroon ng judgment through fame, petition for relief from judgment. Pag nagkaroon ng prevention to prevent him from taking an appeal, petition for relief from judgment. On the other hand, the ground of petition for annulment of judgment are extrinsic fraud and lack of jurisdiction. Okay, sige. Distinguish natin ha. Sige, mamaya. A petition for relief from judgment should be filed within 60 days after the petition learns of the judgment and not more than 6 months after such judgment was entered. Okay, so it must be filed within 60 days after him learning of it, and he should be able to file it within 6 months after judgment. So, isipin natin, pwede niyong malaman yung mangyaring yon within any within the 66-month period, and he should file quickly within the end of the 6 months. Kung nalaman niya after the 6-month period, then he is now barred from filing a petition for relief from judgment. On the other hand, the petition for annulment of judgment, if based on extrinsic fraud, should be filed within 4 years. Yeah, I think 4 years. Or if based on lack jurisdiction before it is barred by laches or estoppel. So pag lack of jurisdiction, laches usually 10 years ang prescription ng ng case. Pero kapag extrinsic fraud, 4 years. Okay. Yes, the CA's dismissal of Mr. So anong tanong sa pangalawa? Was the CA's dismissal of proper? Yes. Bakit? Hindi naman siya prevented from filing, from appealing, di ba? So pwede siyang mag-appeal. Oo nga. Prevented from appealing ba siya? Nalaman niya yung case. Okay. Dinala niya. So, naging final executory noong April 19, 2016. Tapos, binigay niya lang yung decision kay Mr. Yo ng June 1. In short, lapse na yung period to appeal. So, proper na. Nagamitin yung petition for relief of judgment for the basis of the prevention through fame, accident, mistake. Hindi pala. Fraud. So, na-fraud siya, na-extrinsic fraud siya. Okay, so pwede siyang mag-ganon. Pero bakit nga ba mali si CA? Ba't tama pala si CA? Sige. Under the rules of civil procedure, extrinsic fraud shall not be a valid ground for annulment of judgment if it could have been availed of in a petition for relief under Rule 38. Ano daw? So sa rules of Civ Pro, hindi valid ground yung extrinsic fraud for annulment of judgment. Kung pwede ka naman mag-file ng petition for relief. Okay. So, ibig sabihin, sabi dito, dapat nag-file ka ng petition for relief. Mag-file ka within 60 days from the time you learned of the judgment on June 1, which period was also within the 6 months from the entry. Okay. So, tatandaan natin guys is kapag merong fraud, accident, mistake, and excusable negligence, and the extrinsic fraud prevented you from appealing the case in time, then or there was a judgment entered and finalized. So either way, upon the finalization of the decision or upon your failure to file the appeal, you have 60 days from the entry of judgment, 6 months from the entry of judgment, and 60 days from the time you learned of the decision. Tama ba yung naalala ko? Pag annulment of judgment, extrinsic fraud and lack of jurisdiction lang. Pero kapag petition for relief of judgment, ito yung family natin. Fraud, accident, mistake, excusable negligence. Sige. Next. 7 minutes 50. Bilisan natin. Come on. Ba't ganun? Nangyari? Patch isang ganun lang. Anong page nito? Kailangan ko malaman yung page. 84. 73 to 84. Remedial law. 73 to 84. E6 ba yun? Hindi. 810. Hindi. Ito yung kasunod. Ito 12. Bakit ganyan? Sige na nga. Basahin na lang natin. These are received as a subpoena. Copy paste na lang natin para hindi ako mahirapan. Lagay natin dun sa kabila. Haba naman. Okay. Sige. Saan pumutol? Sige, basahin na lang natin straight. Miss R received a subpoena ad testificandum from Regional Trial Court directing her to appear and testify in the case. Despite notice and without any sufficient justification, Miss R failed to appear. This prompted the RTC to issue a show cause order directing Miss R to explain within 10 days why she should not be cited for contempt for her non-appearance despite receipt of the subpoena. Miss R, however, did not file her comment. After due hearing with notice to the parties, the RTC cited her in direct contempt and consequently ordered her arrest. Miss R moved to quash the warrant issued for her arrest, claiming that a formal charge should be filed against her and that the same should have been docketed and prosecuted as a separate case against her. She thus claimed that since this procedure was not followed, the order citing her in contempt is null and void. Question: null and void ba yung contempt niya kasi nga hindi daw na follow yung tagalogin nga natin. Naka-receive ka ng subpoena ad testificandum. Sabi ng court, Miss R, punta ka sa court, mag-testify ka. Tapos, hindi nakapunta si Miss R. So, ngayon, nag-issue ng show cause order si Miss R. Bakit hindi siya dapat ma-cite for contempt? Kasi hindi rin nag-file. Hindi rin nag-reply si Miss R. Okay. Tapos nung nag-hearing na yung both parties, denied siya for indirect contempt. And pina-arresto siya. Ngayon, pina-quash niya yung warrant. Dapat, na dapat may na-file na formal charge against her. Na dapat may docket yun at i-prosecute as a separate case against her. And dahil hindi na sunod yun, sabi niya, yung order citing her in contempt is null and void. Okay, hindi ko alam kung anong tamang sagot dito. Sige, babasahin na natin yung sagot this time. Copy natin to. Sana ito na lang yung last question na ganito yung format. No? Baka haba ito. Haba naman. Yan. No, Ms. R's contention that the order citing her in contempt is null and void is not tenable. Sabi nga, under the rules of civil procedure, proceedings for indirect contempt may be initiated motu proprio by the court, against which the contempt was committed by a show cause order. So show cause order lang enough na to actually initiate the proceedings. Here, there was indirect contempt by Ms. R. Hiwalay natin yung edge method, alak method. To obey a subpoena duly served and the indirect contempt proceedings were initiated motu proprio against the show cause order itself is the formal charge, tama. So yung requirement ng docketing in prosecution does not apply to a contempt proceeding. Okay. The proper, taas ang tanong, next question. What is the proper mode of appeal should Ms. R decide to assail her contempt citation? Will the filing of such appeal automatically result in the suspension of the execution of judgment? Will the filing of such appeal? Pag ba nag-file ka, masususpend na ba yung execution of judgment for contempt? Sige nga, ang sagot. Proper mode of appeal should Ms. R decide to assail her contempt citation is an appeal to the Court of Appeals taken by filing a notice of appeal with the RTC. Under the law on civil procedure, the judgment or final order of a court in the case of indirect contempt may be appealed to the proper court as in criminal cases. Under the rules of criminal procedure, the appeal to the Court of Appeals in cases decided by the RTC in the exercise of its original jurisdiction shall be taken by filing a notice of appeal with the RTC. Ano daw? Ulit. Sabi, yung judgment or final order for indirect contempt, pwede mo siyang i-appeal to the proper court as if para siyang regular criminal case. Pag sa civil procedure. Pero pag sa criminal procedure, appeal to the CA pag decided by the RTC in its original jurisdiction. Notice of appeal with the RTC. Okay? O tapos ano tong no? Ilan ba yung tanong? Dalawa yung tanong dun sa letter B. Will the filing of such appeal okay. No, the filing of such appeal will not automatically result in the suspension of the execution of the judgment. Under Civ Pro, the appeal from a judgment or final order in indirect contempt cases will not suspend the execution of a judgment unless the appellant files a bond. So, kailangan mag-file ng bond ni Miss Art. Okay, sige. 8 minutes. Ang haba naman. In a neighborhood bicycle race, Mr. A bumped the bicycle of one of his competitors. So, sa neighborhood, nagkarera sila. Si Mr. A, nabangga niya yung kalaban niya si Mr. B. Tapos, nawala yung control niya. Tumama siya sa semento. Tapos, namatay si Mr. B. Okay. Now, nakita nung law enforcement agencies, authorities yung nangyari. Inaresto siya without a warrant. Tapos dinala siya to an inquest prosecutor para sa inquest. Tapos na-file yung information for homicide. Walang preliminary investigation. The next day, nag-request siya ng conduct of a preliminary investigation. Pwede mo, letter A, question number 1. Nasa na law enforcement agency, authority. Okay, question number 1A. Is the inquest prosecutor's filing of the information without, yes. Okay, yes. The filing of the information is proper. Under the rules on Crim Pro, no, syempre. Inquest proceedings are proper mode of conducting of determining probable cause for cases involving warrantless arrest. Here, there was a valid warrantless arrest as the law enforcement authorities caught B in flagrante delicto. Hence, the filing of the information after such inquest is proper. Okay, letter B. Yes, the request of Mr. A is permissible. Explain. Explain natin. 2.5%. Under the rules, a request for the conduct of preliminary investigation in cases involving warrantless arrests is permissible provided that the accused, the offender, waives his leaves the period for ano yung wini-waive? Wini-waive siya eh. May wini-waive siyang something. Yes, nasabi ko din, familiar lang ako. Hindi ko alam kung ano yung wini-waive niya eh. Yung article rule something na yun na wini-waive niya. Here, there was an inquest proceeding was done. However, A is not precluded from requesting for an preliminary investigation. Hence, Mr. A's request is permissible. Anong sagot? Yes. Under the rules of criminal procedure, in case of warrantless arrest for an offense requiring the information be filed in court without a preliminary provided, inquest was conducted by the inquest prosecutor. Okay, medyo sobrang hilaw pa nung sagot ko, pero siguro meron naman na akong 3 points dito kahit pa paano, or 4. Tama naman yung concept. May accuse me within 5 days. Within 5 days, kailangan ma-mention yung within 5 days from the time he learns of its filing, ask for a preliminary investigation. Okay. Sige. 5 minutes, 11 seconds. Mr. P was charged with plunder before the Sandigan Bayan, along with several government officials. He filed a petition for bail. Okay. This was objected by the prosecution, which insisted that he should first be arraigned before he applies for bail. Okay. Considering that grant of bail will result the accused fleeing the court's jurisdiction. When is a bail a matter of a right before conviction? Is the object of the prosecution valid? Okay. Ano ba? Paano ko sasagutin to? Bail a matter of right. Ano ba plunder? Paano siya ba ito ba yan? Capital offense ba ito? Hindi naman, di ba? General rule yung tinatanong sa akin, no? When is bail a matter of right before conviction? Sige. Okay. Bail is a matter of right before conviction in cases that are not punishable in by capital punishment. In non-capital offenses. Additionally, under the rules, bail is matter of right. Additionally, bail is still a matter of right for offenses by says where the evidence of guilt is not strong. Generally, under the rules, ayan. Kunyari yung sagot ko. B. Is the objection of the prosecution valid? No. The objection of the
prosecution is not valid. Under the rules, it is not uh, as decided na lang by the Supreme Court. As decided, Supreme Court, bail, uh, arraignment is not an essential requisite. What's called requisite for application for bail. The key factor in determining whether bail can be availed of is whether the court has custody over the person or not. Hence, the objection of the prosecution is untenable. Matter of right, before or after conviction by the MTC. Before or after conviction by the MTC. And before conviction by the RTC of an offense not punishable by death, reclusion perpetua, or life imprisonment. Bail is a matter of right before or after conviction in the MTC and before conviction in the RTC. So in short, before conviction, the evidence of guilt is not strong pa. Pero once you're convicted, strong na yon. Now it becomes a matter of discretion. Yes. No. The objection is not valid. Bakit? The Supreme Court has held that in cases where it is authorized, bail should be granted before arraignment. Otherwise, accused may be hindered from filing a motion to quash since his arraignment would necessarily be deferred pending the resolution of the motion to quash. Okay. This would amount to a substantial dilution of his right to file a motion to quash. Come on. Okay. Daming bar Q&A. Grabe, 4,000 questions. Ilan ba yun? O 20 per subject lang yun. Ba't ang dami? Sige. Next. 6 minutes. Okay. In an information before the RTC, Mr. C was charged with carnapping for purposely for supposedly taking the motorcycle of Mr. O and joyriding it without the round seater. When Mr. C was arraigned, he entered the plea of not guilty to the charge. After the prosecution rested its case, Mr. C proceeded to file a demurrer to evidence. Huh? Ulit, na-charge ka ng carnapping. Tapos nung inarraign si Mr. C, nag-not guilty to the charge siya. Okay, after the prosecution rested its case. So ang issue dito is yung denial ng demurrer. Ano ba yun? Meron bang leave of court yun? Kailangan ba itanong yun kung may leave of court? Kailangan ko ba mag-present ng evidence in his defense after the denial of his demurrer? Na-deny ang demurrer of evidence. So, walang leave of court. No, Mr. C would not be allowed
to present evidence in his defense since there was no showing that cue of court was obtained prior to the filing of the demurrer. Under the rules, if the defendant files a hindi pala defendant, if the accused files a demurrer to evidence. Hindi. Criminal case ba to? Wala pala. Yes, allowed pa din. Sa Civ Pro lang pala yun. Okay, put na lang distinguish. Yes, Mr. C would still be allowed to present evidence. Under the rules on criminal procedure as distinguished from civil procedure, the denial of the demurrer to evidence does not bar the accused to submit evidence, to present evidence as the same would as here this is the rationale criminal cases. The right to liberty is at stake. Under the rules, here, a demurrer evidence was denied during a criminal trial, during the prosecution of a criminal case. Hence, denial of the demurrer evidence will not bar the accused from presenting evidence. Letter B. Assuming that the demurrer was granted by the RTC and prosecution's motion for reconsideration thereto is denied. Okay. Next. Demurrer. Appeal na to. The proper procedural recourse would be to file an appeal, a notice of appeal with the RTC. Under the rules, the grant of demurrer evidence in criminal cases is judgment on the merits. It's a final judgment on the merits. It's a judgment on the merits. Ano to? Hence, the proper mode to proper remedy then is ordinary appeal. Here, there was a demurrer evidence granted for the criminal case. This acquits
the accused and with prejudice party if hence after mode of appeal uh, recourse would be an ordinary to the CA. Hindi pa rin talaga ako confident kung anong rules yung gagamitin ko pang appeal. No? Papansin ko lang. Pero kung ito i-appeal mo from RTC to CA, ano bang rule ang usually na ginagamit? Ano ba yun? Rule 45. Hindi. Wala na pala. O di 65 na. The Supreme Court has held that the grant of an accused demurrer to evidence is equivalent to an acquittal. Ganun. Immediately final yon? Hindi ko alam. O, edi meron pa din. Dapat mag-file ka na ng 65. Pero ang laking learning nun Matic pala yun. Immediately, final. Wala nang appeal. Okay. 9 minutes. Ang tagal ko naman dun. Parang bumagal ako magsagot Okay, tanong. Mr. W was charged with raping his neighbor's 17-year-old daughter. When he was arraigned, Mr. W expressed his desire to plead guilty, provided that his sentence be substantially reduced. Yung mother ni AAA at saka yung prosecutor, okay naman sila sa proposal. Consequently, nag-enter ng plea of guilty si Mr. W. And nasentence siya to reduce straight penalty of only 10 years of imprisonment as agreed. Did the judge properly enter a plea of guilty for Mr. W? Teka nga. Sabi niya, si Mr. W, in-express niya lang yung desire niya mag-plead guilty. Provided that his sentence be substantially reduced. So, anong parang sabi? Plea bargaining agreement ba to? Hindi. Kung walang plea bargaining agreement, at straight out, express the desire to plead guilty, pero hindi siya nag-plead guilty actually, a plea of not guilty should have been entered. Okay. No. The judge, in the first place, bakit mo itatanong sa akin kung proper yung enter a plea of guilty, kung tama naman yun? Malamang mali. Tama ba? No, the judge not enter a proper plea of guilt for Mr. W. Under the rules decided by Supreme Court, when the accused pleads guilty to a lesser offense, a plea of not guilty shall be entered for him. Here, the accused only expressed his desire to plead guilty to a lesser offense. Hence, the proper plea of guilt that should have been entered by the judge is a plea of not guilty. Letter B. Assuming that Mr. W was once more charged with a crime of rape committed against AAA based on the same incident, Mr. W validly invoked the defense of double jeopardy through a motion to quash, and will such motion prosper? So consequently, the judge entered the plea of guilty and sentenced him to serve a reduced straight penalty. Ano bang sagot dito? So kung mali yung plea of guilt, hindi nag-obtain ng valid jurisdiction ng court. Hence, that prior decision is null and void for want of jurisdiction. Hence, another case filed for this same instance would not be double jeopardy. Okay. Sige. And bakit may tatanong sa akin yan kung, di ba, hindi naman siya issue? Okay. No, Mr. W cannot validly invoke the defense of double jeopardy. Under the rules, when the court is decides a case without a valid jurisdiction, the decision rendered by such court is invalid. Here, in the accused was not validly arraigned as a wrong plea of guilt was entered for him. Consequently, the void was not able to obtain jurisdiction over the person of the accused. Hence, the court having no jurisdiction the decision rendered is void, shall be deemed void, and cases filed for the same offense later on shall not be barred by res judicata. Double jeopardy. Okay. Res judicata. O sige, tingnan natin. No. O, diba? Galing natin manghula. Guys, galing natin mag-bola-bola system. O, anong sagot? No, the judge didn't properly enter a plea of guilt. Under the rules of criminal procedure, when accused makes a conditional plea, a plea of not guilty shall be entered for him. Conditional plea pala ang tawag. Oh, sayang, yun yung term na kailangan nung para i-5 points ako eh. Here, the accused Mr. W made a conditional plea when he expressed his desire to plead guilty, provided that his sentence be substantially reduced. Hence, the court should have entered then a plea of not guilty rather than one of guilty. O, decision pala yun ng court of People versus Magat. Last question, no. Mr. W may not validly invoke the defense of double jeopardy through a motion to quash, and such motion will not prosper. Under the rules, under the law on criminal procedure, a requirement of double jeopardy is that the first judgment of conviction or acquittal must have been a valid judgment. Here, the judgment rendered by the trial court was void ab initio.
Yung mga legalist, no, void ab initio. Di ba? Pero hindi ko nasabi yun. Kailangan kong magamit yung mga void ab initio na yan. Since there was no valid standing plea made by the accused, Mr. W. Here, since the judgment of conviction rendered against the accused was void, double jeopardy will not lie. O, tama tayo. Dapat mga 4 points man lang yan. Kahit hindi ko nagamit yung tamang words, no? It's not a full point. Pero sana mabait naman yung judge, yung examiners natin. 8 minutes. Tagal itong nagsagot. Gravity. Gravity. Okay. In the case, for specific performance and damages, plaintiff Q presented photocopies of the contracts he had executed with defendant R for the purpose of establishing their existence. Defendant R's counsel objected to the omission of said photocopies, invoking the best evidence rule. Luma na yung best evidence rule. Wala na yan. O, dapat bang sustain daw? Paano nga ulit? Kapag sinustain ang objection ni R, ibig sabihin, hindi na pwedeng magtanong, hindi i-allow yung tanong at yung sagot. Okay. Sige. So, ang sabi ni R's counsel, photocopies, hindi pwedeng i-admit kasi may best evidence rule. No. R's counsel. Hindi pala. Pag sinustain mo yung objection ni R, ibig sabihin ng tama siya. Hello? Dito pa rin ako sa objection na to eh. Pag sinustain, si defendant R, yung counsel niya, nag-object. Pag sinustain yung objection niya, tama siya. So, dapat i-overrule. R's counsel objection should be overruled. Under the revised rules on evidence, the best evidence rule is not applicable. What governs now is the original document rule. Under such rule, the original document rule, photocopies of documents are deemed as duplicates. Duplicates are counted as original documents. Evidentiary purposes. And it can be shown why the original document is not available for presentation. Here, photocopies were presented by Q. Hence, the same shall be admissible in court. B. Assuming that the best evidence rule applies, under what circumstances will the photocopies be admissible in evidence? Best evidence rule pa ba nag-a-apply? Hindi ba original evidence rule na? Ano gagawin ko dito? It will photocopies shall only be admissible under the best evidence rule if such photocopies have been duly notarized and or authenticated by the parties. Two. Okay, ang sagot. Ha? People versus Tandoy. Best evidence rule only applies to documentary evidence. Object evidence. So ang distinction dito, the admission of the photocopies. Kapag nag-i-inquire ka into the contents of the evidence, that is counted as documentary evidence. But if you are just presenting a photocopy for the purposes of proving na nag-exist yung contract, no? And you're not inquiring to the contents of the contract, then it is now classified as object evidence. And with object evidence, the best evidence rule does not apply. Okay. Pag na-encounter ko tong tanong na to, people versus Tandoy, hindi ko matatandaan yung pangalan. Hindi ako palatandaan yung mga pangalan ng case. Pero matatandaan ko yung concept. Okay. Assuming that the best evidence rule applies, the photocopies will be admissible if the proponent Q should prove first the execution or existence of the original contract, should then prove the cause of the unavailability of the original contract without bad faith on his part, and should then prove that there was reasonable diligence and good faith on his part in trying to produce the original. Grabe ko ba yung best evidence rule ngayon? Tapos na eh. Matatanong pa ba ito sa bar? Hindi natin alam. Pero at least, pag natanong sa bar, alam natin. Kahit pa paano. Hindi na sila mga first time na makikita natin sa bar, no? Sige. In case for attempted parricide brought against Mr. M by his wife, Mrs. N, their son was called as a witness for the prosecution. Mr. M's counsel objected involving the filial privilege rule. Meanwhile, in a separate case for serious physical injuries also brought against Mr. M, but this time by his son, Mrs. N was called to testify. Okay, marital disqualification rule. Okay, sige. Attempted parricide, si Mr. M papatayin ni N, ng wife niya. Si San tinawag as a witness. Mr. M objected invoking the filial privilege rule. Tapos doon naman sa separate case ng separate physical injuries by M to C, his son, nag-testify naman si N against Mr. M. Okay, alam ko na sagot. No. The objections should be overruled. Under the rules on evidence, codal to. Basically, sinasabi, the exception to the filial privilege rule and the marital disqualification rule is when the case involves the spouses filed is as to an offense by one spouse. Teka. Against the other. Or the latter's legitimate direct legitimate ascendants and descendants.
to the marital disqualification rule. This file is ano, and the offense when the offense was committed by one spouse against the other. On the other hand, the exception for the filial privilege rule is when the parent or children committed an offense against the other and the latter's direct descendants or descendants. Here, the offenses was committed by Mr. Teka nga, mali pala, no? So, si N, yung asawa niya, sinaktan ni Mr. M. At sinaktan niya rin yung anak niya. Okay, the offenses were, ano ba, Carl? Were committed by Mr. M against his wife and child. Hence, the exceptions apply and the objections of Mr. M's counsel shall be overruled. You're the one invoking the filial privilege, not the witness, but the ascendant against whom the witness is being called upon to testify. Hence, objection should be overruled. Okay na yan. Maikli yung sagot ko pero parang it does the job. Okay na to. Sana 4 points man lang, no? 4 to 5 points. Masaya na ako dyan. 648. Okay, game. A criminal complaint for theft was filed against Mr. T by his employer for allegedly stealing company property. During trial, the prosecutor called Mr. T's former supervisor, Mr. V, to the stand and attempted to question him on similar incidents also involving Mr. T with his previous employer. Mr. T's counsel objected to the question, invoking the rule on res inter alias acta. Shit, ano nga ba ibig sabihin niyang inter alias acta na yan? In response, the prosecutor should be argued that the question should be allowed since he was trying to establish Mr. T's habit of stealing things from the workplace. Ano bang question? Should the objection of Mr. T's counsel be sustained? Explain. Ano ba sabi nung Mr. T's counsel? Mr. T objected to the question, invoking the rule on res inter alias acta. Shemay, hindi ko alam yan. Okay. Copy-paste na lang natin kagad. Pag nanghula ko, mali yan. Assume natin mali yan at 0 yan. I mean, bigyan nila ako 1-2 points, no? Pag binulabola ko yan. Pero for purposes of studying, hindi ko siya hulaan dahil sayang ang oras. Mamadali tayo mga kababayan. Yes, the objection of Mr. Khan should be sustained. So that the Supreme Court has held that the courts must contend with the caveat that before they admit evidence of habit as an exception to the rule on res inter alias acta, the offering party must establish a degree of specificity
and frequency of uniform response that ensures more than a mere tendency to act in a given manner, but rather conduct that is semi-automatic in nature. In determining whether the examples are numerous enough and sufficiently regular, the key criteria are adequacy of sampling and uniformity of response. Here, there is no showing that a similar incidents with the previous employer of the accused are numerous enough and sufficiently regular to establish a conduct on Mr. T's part that it is semi-automatic in nature. Hence, the objection of Mr. T's counsel should be sustained. Ano ba yung res inter alios acta? A thing done between others. It's a principle that says that an act, declaration, or omission of one person cannot prejudice the rights of another who is not party to that act. In a simpler term, a matter between two people does not affect a third party who was not involved. Okay. Pinag-aralan ko to eh. Alam po na-discuss natin to doon sa evidence nung nag-aral ako nung reviewer ng evidence base ni Attorney Larena. So, pero hindi ko siya naalala. Res inter alios acta. Though third parties cannot be damaged by the agreement of two parties. Parang ganun yung sinasabi nun. So here, parang sinasabi, irrelevant yung nangyari sa kanila versus ang nangyayari ngayon. Pero an exception to that is to the exception to the rule on res inter alios acta, there must be the establishment, the degree, it must be to establish the degree of specificity and frequency of uniform response that ensures more than a mere tendency to act in a given manner, but rather conduct that is semi-automatic in nature. Ang haba. Ang haba niya exception na yan ha. Pero sige, maalala ko yan sana. The second question, assuming that the prosecution presents evidence on the bad moral character of Mr. T, may the same be admitted in the present case. Generally speaking, evidence on moral character, iba nga pala yun sa civil at criminal cases, hindi ko maalala. Sige, assuming that the prosecution presents evidence on the bad moral character of Mr. T, the same may not be admitted in the present case. Under the rules of evidence, the prosecution in a criminal case may not present evidence of the accused's bad moral character unless in rebuttal. Okay. Hindi ka pwede mambash. Sa rules on evidence, the prosecution in a criminal case may not present evidence of the accused's bad moral character. So, hindi pwedeng prosecution ang mag-present. Ang mambash sa'yo na, ganito ka naman, ganito, ganyan, ganyan. Pero, merong but. Kapag meron siyang sinabi na, mabait po itong aming accused, ganito, ganyan, ganyan. Then, on rebuttal, the prosecution may now bash, validly bash the bad moral character of the accused. Okay. Sige. Move on. 4 minutes 53 just to understand that answer. Sige. A 10-year-old minor was sleeping inside her room when she was awakened by her uncle, Mr. G, who was reeking of alcohol and was already on top of her. After Mr. G, who was reeking, succeeded in having carnal knowledge of AAA, the former immediately left the latter's room. Thereafter, AAA rushed into the room of her mother, MMM, and spontaneously and frantically reported the incident. Eventually, Mr. G was arrested and was indicted for the crime of rape. During the trial, MMM was presented as a witness to testify on what AAA reported to her and AAA's gestures and disposition at that time. Mr. G's counsel objected to MMM's testimony on the ground that it is hearsay evidence. The prosecutor countered the subject of MMM's testimony may be admitted as an independently relevant statement and as part of the rest to stay. The subject of MMM's testimony may be admitted as an independently relevant statement as part of the rest to stay. Okay, tanong. May MMM's testimony be admitted on the ground that it constitutes an independently relevant statement? Yes. The same may be admitted. MMM's testimony is admissible under the rules. An exception
to the hearsay rule is that is when the testimony is an independently relevant statement. This means that the statement of a witness as to what he or she heard he or she heard. This means that the statement of a witness as to what he or she heard is counted as personal knowledge as to what was said to him or her. This does not the issue of whether what was heard, him or her, is a separate matter. Here, MMM is testifying as to her own knowledge, personal knowledge of what was said by AAA at that time. Hence, it should be admissible as an independently relevant statement. Letter B. May AAA's statement to MMM be admitted on the ground of res juste? AAA sa MMM's testimony may be admitted as an independently relevant statement as part of the res juste. May AAA's statement to MMM be admitted on the ground of res juste? Spontaneously and frantically reported the incident. Yes, it may be admitted as part. Hindi eh. That's just day. Ang nakaka-capture si MMM. So dahil sinabi ni MMM, parang no. Hindi eh. Hindi, no. No. Cannot be admitted. Under the rules. The ground of res juste as an exception to the hearsay rule is only applicable when testimony is directly from the affiant himself. Here, the testimony, the supposed statement of AAA statement is only based on MMM's testimony, hence it cannot be admitted as part of the res juste. Yes, no, please. Yes, no, please. No.
Hindi pala admissible. MMS testimony regarding what AA reported to her may not be admitted as an independently relevant statement. Okay, an independently relevant statement is a statement which is relevant for something other than for its truth. Here, AA's statement on how he was ravaged by Mr. G could have been offered for no other purpose than for proving the truth of her statement. Hindi ko na-gets ang pinagkaiba ng independently relevant statement. Here, AA's statement on how she was ravished by Mr. G could have been offered for no other purpose than for proving the truth of her statement. Relevant for something other than for its truth. Okay, gets. So kung yung offering ng statement is not for its truth whatsoever, then it's an independently relevant statement. Pero kapag kailangan totoo yung sinasabi ni MMM, and yun yung purpose na sinasabi niya yun, then it's not an independently relevant statement. It's not hearsay. Hindi relevant statement kasi okay. So, ang tanong, yung MMM's testimony be admitted on the ground that it constitutes an independently relevant statement. So, parang yes or no ang sagot. No, as to ano yung sinabi ni AAA sa kanya. Yes, as to the disposition and gestures ni AAA na nakita niya. They are not statements but facts na perceive ni MMM directly with her own eyes. So, yun ang admissible. Okay, that's a good distinction. Tapos ito naman, zero talaga ako dito. Yes, AAA statement to MMM may be admitted on the ground that it is part of the res state. Under the rules of evidence, statements or utterances accompanying a startling occurrence made immediately thereafter and regarding the circumstances thereof are an exception to the hearsay rule as part of the res state. Statements or utterances accompanying a startling occurrence made immediately thereafter and regarding the circumstances thereof are an exception to the hearsay rule. Here, a statement was made immediately after a startling occurrence, that is, her ravishment under the hands of her own uncle and regarding the circumstances thereof. Hence, a statement is part of the res state and inadmissible in evidence as an exception to the hearsay rule. Okay, mali tayo. 0 points for that. No points were given for that question. Wala tayong tinama. Sagot. Ewan ko baka. Wala, hindi ko naman sinabi yung disposition and gesture. So, matik, mali na agad ako. Boy. Ay, buti na lang hindi po to bar. 10 minutes yung na-take ko dun. Ang tagal ko magsagot ngayon ang hirap ng mga tanong Hindi siya mga basic question kagaya ng umpisa last time. Ang hirap ng mga tanong. Dadali din to. Pasasaan pat dadaloy ang ginhawa. Daniel, a Filipino citizen and permanent resident of Milan, Italy, filed with the Regional Trial Court of Davao City where she owns a rest house. A complaint for ejectment against Dan. Kaya nga, tanong muna, was there a need to refer the case to the Lupong Tagapamayapa for prior barangay conciliation? And was the action properly instituted before the RTC of Davao City? Okay, yun ang question. So, si Daniel, Filipino citizen and permanent resident of Milan, Italy, filed with the Regional Trial Court of Davao City where she owns a rest house. A complaint for ejectment against Dan, a resident of Barangay Daliao, Davao City. Okay. Daniel's property which is located in Digos City, Davao del Sur, has an assessed value of 25,000 pesos. Appended to the complaint was Daniel's certification of non-forum shopping executed in Davao City, duly notarized by Attorney Dane Danoza, a notary public. Question, was there a need to refer the case to the Tagapamayapa for prior barangay conciliation before the court can take cognizance of the case? Kailangan ba? Ano ba yung cases na kailangan ng barangay conciliation? Hindi ko rin alam. Ano ba to? Nag-aaral ako, hindi ko alam. Kaya nga tayo nag-aaral, di ba? Feeling ko, ano siya, hulaan ko na lang, zero na muna yung sagot ko dito. For barangay conciliation, hindi. Hindi naman kailangan i-refer for barangay conciliation to kasi hindi naman sila magkabarangay. Resident siya ng Milan eh. Hindi na sila sa resident parehas. So, no. Second, was the action properly instituted before the RTC of Davao City? Should the complaint be verified or is the certification sufficient? Was the action properly instituted before the RTC of Davao City? Hindi. Eh, di ba nga, ang primary jurisdiction ng ejectment cases or unlawful retainer cases is vested with the MTC. Should the complaint be verified or is the certification sufficient? Sige, sagutin natin ng konti. A, no. B, no. MTC for, ano to? Ejectment cases. Unlawful detainer. Okay. Tapos C, should the complaint be verified or is the certification valid? May certification non-forum shopping executed in Davao City. So, kailangan bang verified? Or yung certification is enough? Kailangan verified. Kailangan notarized. Verified. Okay, sige. Tingin. Sagot? No? Hindi siya resident. Okay. Ayun pala, may katarungang pambarangay law pala. Okay, no. NTC. Yes. Lawful detainer. All pleadings submitted to court be verified po. Tandaan natin yan. Siguro mabibigyan ko yung sarili ko ng mga 3 points dahil tama naman yung mga no yes ko. Sige, from here on out, ganun na lang sagot natin. Pwede ba yun? Practice ba tayo pag ganun yung pasagutan natin? Magmamadali tayo. Sige, kapag full confidence, sasagutin ko ng full answer. Kapag duda ako, quick answer lang, hula lang. Okay. Okay, next. 4 minutes 30. Yeah. Ganyan dapat kabilis. 4 minutes 30. Then, Denise. Ano to? Will you grant the motion to dismiss? Okay, sige. Question. Then Denise Incorporated and David, both stockholders owning collectively 25% of Darwinkel Incorporated, filed an action before the RTC of Makati to compel its board of directors to hold the annual stockholders meeting on June 21, 2017 as required by Darwinkel Incorporated's bylaws, with prayer for preliminary mandatory injunction to use as record date, April 30, 2017. The complaint alleged, among others, that the refusal to call the ASM on June 21, 2017 was rooted in the plan of the BOD to allow Databank Incorporated to participate in the ASM to effectively dilute the complainant's shareholdings and ease them out of the board. Filing fees should have been based on the actual value of the shares of Denise and David, which were collectively worth 450 million. Ang rule sa motion to dismiss, lack of jurisdiction. Okay. Jurisdiction, an action. Okay, so intra-corporate dispute to basically, no? Annual stockholders meeting. The refusal to call the stockholders meeting to allow Databank to participate in that stockholders meeting. Okay. So, nag-file sila ng 7565 based on the assessment of the clerk of court. So, nag-file ang BOD. ng motion to dismiss on the ground of lack jurisdiction. Sabi nila, ang filing fees dapat based on the actual value of the shares of Dendenis Incorporated and David. Oh, motion to dismiss on ground of lack of jurisdiction. Meron bang distinction kung magkano ang ownership? Di ba the RTC is acting as um, intra-corporate dispute court something? Hindi ko alam. Hindi ko talaga alam. Manghula ako. Ayoko manghula. Basahin na lang natin yung sagot. Sana maalala ko na lang. No, while the payment of the prescribed docket fee is a jurisdictional requirement, even if it's non-payment at the time of filing, does not automatically cause the dismissal of the case. Tama yun. Procedurally. The court may allow payment of the fee within a reasonable time, but in no case beyond the applicable prescriptive or reglementary period. Here, Dendenis Incorporated and David really relied on the assessment made by the clerk of court. If incorrect, the clerk of court has the responsibility of reassessing how much they must pay within the prescriptive period. Okay. Yun ang issue. Ang issue is, yung non-payment ba ng docket fee is a jurisdictional requirement. Ano pala? Non-payment of docket fee is a cause for the dismissal of the case. And the answer has been held in multiple cases is that it's no. Okay, sige. 3 minutes 53. Okay, next. On February 2018, Danny De Lucia, Sheriff of the RTC of Makati, served the order granting the ex parte application for preliminary attachment of Dinggoy against Dodong. The order. Kaya talaga ng mga special civil action at provisional remedies. Kaya yung kahinaan ko. So dapat manood pa ako ng more nun. The order together with the writ was duly received by Dodong. On March 1, 2018, the sheriff served upon Dodong the complaint and summons in connection with the same case. The counsel of Dodong filed a motion to dissolve the writ. Can the preliminary attachment issued by the court in favor of Dinggoy be dissolved? What grounds can Dodong's counsel invoke? Napagod ako doon sa question. Pag gano'n. Nakakapagod. Pag ayaw mo ng topic, napapagod ka doon sa question. Yung writ issued by the court in favor of Dinggoy be dissolved. Bakit? Bakit hindi dissolved? Nag-file yung motion to dissolve yung counsel ni Dodong. So, nagkaroon ng ex parte application for preliminary attachment. Kailangan niya ng hearing. Yes. Yun yung issue. Yes. The writ may be dissolved. Dodong's counsel may invoke the rules on civil procedure mentioning that the issuance of writ of preliminary attachment may not be applied for ex parte a hearing or same separate hearing shall be conducted for the purpose of determining whether the issuance of such writ is valid, is necessary, and to provide an opportunity
for the opposing counsel party to file a supersedeas bond if necessary. Letter A. If Dodong posts a counter bond, is he deemed to have waived any of his claims for damages arising from the issuance of the order and the attachment? No, he is not deemed waived. Claims for damages. However, Dodong must ensure that the bond he is that the counter bond he is posting already includes the damages and claims arising from the issuance of the order of attachment. Failing to do the same would bar him from okay. Yes. The court enforcement order was proper. Once the court must have acquired jurisdiction of the defendant, or without such jurisdiction, the court has no power or authority to act in any manner against the defendant. Consequently, any order issuing from the court will not bind the defendant. It is thus indispensable not only for the acquisition of jurisdiction of the person of the defendant, but also upon consideration of fairness to apprise the defendant of one complaint against him and the issuance of a writ of a preliminary attachment and the grounds served. Therefore, that prior or contemporaneously to the serving of the writ of attachment service, together with a copy of the application for attachment, the applicant's affidavit and all must be served upon him. So, dapat may service upon him at least, at the very least. So, hindi kailangan na hearing pero dapat merong service. In this case, since copies of the complaint and summons were served after the writ of preliminary attachment was served, upon Dodong, the writ therefore was improvidently issued. The writ of preliminary attachment may be dissolved. Okay, no, the posting of a counterbond does not amount to a waiver of his claim for damages arising from the issuance of the order and the writ of attachment. The counterbond and the claim for damages pertain to two different aspects in the issuance and implementation of a writ of preliminary attachment. A counterbond posted by the person against whom the writ of preliminary attachment was issued does not answer for damages on account of the lifting of the attachment, but for the payment of the amount due under the judgment that may be recovered by the attaching creditor. The counter bond stands in place of the property so released. On the other hand, the claim for damages by the person against whom the writ of preliminary attachment was issued is governed by Rule 57, Section 20 of Rules of Court, which states that an application for damages on account of improper, irregular, or excessive attachment must be filed before the trial or before appeal is perfected or before the judgment becomes executory with due notice to the attaching party and his surety or sureties setting forth the facts showing his right to damages and the amount thereof. Such damages may be awarded only after proper hearing and shall be included in the judgment of the main case. Considering that the rules of court provided different purposes for the filing of a counterbond and the filing of claim for damages, Dodong's posting of a counterbond cannot be deemed a waiver of his claim. Ang haba, pwede naman ito na lang isugot pero okay. I think still ang ganda kapag ganito yung discussion for purposes of review, no? Kasi talaga maintindihan mo bakit nga ba ganun yung sagot, 'di ba? Kasi kung mababa lang yung discussion, paano mo maintindihan? Paano mo ma-absorb
Pero to talagang, alam mo yun, binabad ka niya talaga dun sa concept. Dinastify niya sa'yo paulit-ulit. Yung mga abogado talaga ito, mahilig mag-justify na sarili nila eh. Hindi, pero in real life, guys, we really don't have to justify that much. We just have to put it in paper if needed. And kung mga regular naman ng mga usapan, uh, we just provide our thoughts. Unless hinire naman nila tayo sa abogado at case law, then that's the only time we provide this full disclosure, lengthy documents whatsoever. But for purposes of discussion lang naman, hindi naman kailangan ganyan kahaba. Yung mga sagutan ko, yes, no, yes, pwede na siguro yun. Mga 4 points na yun sa mga kausap mo. Actually, kapag hindi naman justice ang nag-check ng sagot mo, mga regular na tao nagtatanong ng kaso nila, oh, Carl, paano pag ganito, ganyan? Hindi naman ganun kataas ang standard. Diba? Mali pa naman nila yung sagot mo, tama o mali. I-hire ka muna nila as abogado. Yan. Saka mo talaga ididig deep kung ano dapat gawin, ano yung details, ano yung evidence available, pag samasamahin mo lahat yan, and ayan, you concoct up beautiful case. Okay? Si Dixon. Dick, ang two dismissal rule apply, making the second dismissal with prejudice. Okay, sige. Dick Dixon had sons with different women. Ay, hindi pala ako nakapag-lap. 9 minutes. Dick Dixon had sons with different women. Dexter with a long-term partner Dahlia and Dong and Ding Dong with his housemate Divina. When Dick fell ill in 2014, he entrusted all his property titles and shares of stocks in various companies to Delia, who in turn handed them to Dexter for safekeeping. Okay. Okay. So, anak niya si Dexter with Delia. Mas marami siyang anak dun sa house, may di lang si Divina. Ano ba? Dick Dixon. Sorry na judge po kita. After the death of Dick, Dexter induced Dong and Ding Dong to sign an agreement and waiver of their right to Dick's estate. In consideration of 45 million pesos. As Dexter renegade on his promise to pay, Dong and Ding Dong filed a complaint with the RTC of Manila for annulment of the agreement and waiver. The summons and complaint were received by Dahlia, the housemaid of Dexter, on the day it was first served. Dexter filed a motion to dismiss on the ground of lack of jurisdiction over his person. RTC Manila granted the motion to dismiss. Ang question dito is, yun bang receipt ni Dahlia? Housemate ni Dexter. Valid ba? Ginrant ng RTC Manila yung motion to dismiss na wala siyang jurisdiction. Okay, so without prejudice yung una. No? Kasi invalid service of summons lang naman. Dong and Ding Dong therefore filed a new complaint against Dexter for annulment of the agreement and waiver. Okay, before Dexter could file his answer, Dong and Ding Dong filed a motion to withdraw their complaint, praying that it be dismissed without prejudice. Ano daw? Withdraw nila yung complaint. Bakit? An order was issued granting the motion to withdraw without prejudice on the basis that the summons had not yet been served on Dexter. Okay. Dexter filed a motion for reconsideration of the order of dismissal. He argued that the dismissal should have been with prejudice under the two... Anong ginagawa mo, Dexter? Ano ba ginagawa ng abogado mo? Bakit? Dismissal with prejudice? Wala pa nga kayong discussion? Inurong lang yung kaso? Kasi may two dismissal rule sa Rule 17. Feeling ko two dismissal rule, kapag ang cause, hindi ko alam kasi eh. Manghula ako, no, the two dismissal rule only applies when the withdrawal of the case is by virtue of the motion of the plaintiff for 2 times. Parang ganyan. Tignan natin. Pero hindi ko alam yung two dismissal rule na yan. There was a previous case that was dismissed by a competent court. Both cases were based on or include the same claim. Both notices for dismissal were filed by the plaintiff.
Oh, galing natin manghula guys. Kaya ko tong craft ng 5 points. Kung ang 5 points is ito, siguro mga 3-4 points lang ako kasi hindi ko naman i-enumerate lahat yung mga requisites na yan. Hindi naman nare-require yan, di ba? Required ba yan? Hindi ko din sure. Sige, game. Shit, 11 minutes na lang. Matatapos ng 2 hours. Makapagpahinga tayo sa ating Pomodoro. Okay, next. Kailan na ako? 17 questions na ako, guys. Okay. So, ang target ko is maka 50 daily. 55. Pero gusto ko maka 100. Kaya ko ba maka 100 until 6 a.m.? Challenge ko yung sarili ko maka 100 until 6 a.m. On average kasi kinompute ko na in 4 hours na target ko mag-aral everyday. With 7 minutes na target na magsagot on average ng bawat tanong, it would take me 10 to 11 days. Pero pag titignan mo pala, pag nagsagot ako, I can accomplish, for instance, 50 questions in 2 hours. 25 questions in 2 hours. Then 50 questions in 4 hours. Then I can accomplish 100 questions in 8 hours. Ang goal ko ngayon, makatapos ako ng 100 questions in 4 hours. Kaya ba natin yun? Kaya. Bakit naman hindi? Diba? Sige. Dahil naka-record naman tayo sa live, sasagot na lang ako orally ngayon. Ha? Hindi ko na i-check yung sagot ko kung tama o mali. Nandiyan naman sa recording eh. Babasahin na lang natin yung sagot after ko sumagot orally. Okay lang ba yun? That should drastically reduce the time spent for each question. Sige, testing natin. Dorton Incorporated sued Debra Commodities na tanong. RTC of Manila considered the promissory note and the surety agreement in rendering its decision. Okay. Dorton sued Debra. Daniel and Debbie in the RTC of Manila for sum of money. Sabi sa complaint, noong October 4, 2017, nangutang si Debra kay Dorton ng 10 million pesos, 9% annum. The loan was evidenced by a promissory note na pinirmahan ni Daniel at ni Debbie. So parang naging solidarity debtor sila. The principal stockholders of Debra. Okay. Okay. Who also executed a surety agreement binding themselves as sureties. Okay. Sureties na sila. Copies of both the PN and the surety agreement were attached to the complaint. Now, Dorton further alleged, naniningil, that it made a final demand on March 1, 2018 na magbayad sila, but the demand was not heeded. Debra, Daniel, and Debbie filed their answer and raised the affirmative defense that while the promissory note and the surety agreement appear to exist, Daniel and Debbie were uncertain whether the signatures on the documents were theirs. The PN and the surety agreement were pre-marked during trial, identified but not authenticated during trial, and formally offered. Okay, question ngayon. Pwede ba daw i-consider yung PN and surety in rendering the decision? So the question, ang pinakamalapit na question is hindi siya na-authenticate. So parang issue is, dahil hindi ito na-authenticate, pwede pa ito i-consider ng court? Yes! Hindi na kailangan i-authenticate. Hindi kailangan, kasi kumbaga yung existence ng promissory note, the affirmative defense of the opposing parties effectively, this is a negative pregnant, effectively confirm that there is indeed a loan. And that's what needs to be established here. So in that case, kung titignan mo, itong pwede na itong i-file for motion for judgment on the pleadings na to eh. Tama ba? Judgment of the pleadings. Oo, kasi wala nang case or controversy eh.
Ang issue na lang yung signatures. Pero as to the amount, it's already there. And surety man sila, primarily liable pa rin naman si Debra. 'Di ba? Okay. Interesting. Ang dali ng tanong kapag alam mo yung sagot, kapag napag-aralan mo. May answer. Oh, hindi ko tatype. The RTC of Manila, yes, the RTC of Manila can consider the promissory note and surety agreement in rendering institution. Under the rules of court, a negative pregnant is a negative pregnant statement is an effective is hindi pa ito negative pregnant. It is an affirmative defense na nga eh. Sige. Under the rules of court, a negative pregnant statement is one where even though wag na negative pregnant, under the rules of court, if there is no justiciable controversy being discussed in the case, the same may be filed for judgment. Hindi pala. Ang tanong is, pwede bang i-render yung, pwede bang consider? Sagot, yes, the RTC of Manila can consider the PN and the surety agreement. Type ko na lang. Ang hirap, hindi ko naman sasagot ng diretso. The RTC can consider the PN and the surety agreement. Okay. Under the rules, paano ko ito a document may be offered in evidence as object evidence if the same is offered not for the purpose of inquiring as to its contents, but rather as to prove the existence of a fact. Here, the PN and surety agreement was offered as object evidence to establish the existence of the loan, which is the basis of the cause of action of Dorton against the defendants. Hence, the PN and surety agreement may be considered are admissible as object evidence and the RTC may consider them in rendering its decision. Mas madali pa rin pala talagang i-type kasi oral. Unless superhero ka na kaya mo sagutin kagad, no? Siguro after ko ng ilang try or actionable documents as a written, that when an action is founded upon a written instrument copied in or attached to the corresponding pleading, the genuineness and due execution of the instrument shall be deemed admitted unless the adverse party under oath specifically denies them. So parang dapat sinabi ko na kapag merong actionable document attached to the corresponding pleading, the genuineness and due execution is deemed admitted unless specifically denied by the adverse party. In this case, since attached to the complaint are deemed to have admitted the genuineness and due execution because they have a failure to deny the genuineness and due execution of these documents under oath. And to set for what they claim to be facts. Okay. Yun pala. So, allegation, action or defense based on document. So, parang merong deemed admission. O, kasi hindi mo na specifically, tawag dyan, gets. Laking tulong nun. Laking tulong nun. Pag na-encounter ko to sa bar, medyo maaalala ko tong tanong na to. Okay. 1 minute left. 10 minutes ko sinagutan yun. Ang dami ko kasing daldal. Caribel. Ito na makahaba to. Okay. Daribel filed a complaint for sum of money and damages against spouses Dake and Donna de Mapilis for unpaid purchases of construction materials in the sum of 250,000 pesos. Teka ano muna question? Is the request for admission deemed abandoned or withdrawn by the filing of the second amended complaint? Oo. Kapag nag-withdraw ka or nag-file, yes. Pag nag-file ka ng amended complaint, it means bago siya ulit. Ulit tayo, no? Nag-file ka ng second complaint, bago ulit. Can the amendment of the complaint be allowed if it substantially alters the cause of action? No. If substantially alters the cause of action, then it must be dismissed and another case shall be filed. Can the fact subject of an answered request for admission be the basis of a summary judgment? Can the facts subject of an unanswered request for admission Sige nga, basahin natin. Daribel filed a complaint for sum of money and damages against spouses Dick and Donna de Mapilis for unpaid purchases of construction materials in the sum of 250,000 pesos. In their answer, spouses de Mapilis admitted the purchases from Daribel but alleged that they could not remember the exact amount since no copies of the documents were attached to the complaint. They nevertheless, Tagalogin na natin from the top. Si Daribel naniningil kay Dick and Donna kasi bumili sila ng construction supplies, 250,000 pesos. In their answer, sabi nung mag-asawa, oo, meron kaming binili sa'yo. Pero hindi namin maalala magkano ba yung utang namin kasi wala kaming, wala kang na-attach dun sa complaint mo. Pero sabi nila, nagbayad sila ng 110,000 and 20,000. And okay naman silang bayaran yung balance after ma-verify kung magkano pa yung kulang. Tapos, sabi ng spouses, para magkaroon na tayo ng kapayapaan, magbabayad kami ng 250,000 pero wala nang interest and cost. Settle na natin to. Tapos sabi ni Daribel, pwede bang mag-partial summary judgment na tayo? Tapos, si Daribel nag-file ngayon ng amended complaint. Sabi niya, yung total na purchases nyo sa akin, 280,000. And 20,000 lang ang nabayaran nyo. Daribel also served upon the spouses. Sinasabi niya na i-admit to the genuineness of the statement of accounts, delivery receipts, and invoices as well as to the value of the principal obligation and the amount paid as stated in the amended complaint. Okay. Daribel thereafter amended the complaint anew. Ano ba to si Daribel? The amended modified the period covered and confirmed the partial payment of 110,000 but alleged that this payment was applied to the spouses after other existing obligation. Darrell, however, reiterated that the principal amount remained unchanged. Ano ba to si Darrell? Ano ba yung abogado mo? Pag ako naging abogado, ganyan din ako. No? Ayoko na magkaso. I-insure ako mga tao. That's my goal. Pero sige, nagtira na ako eh. Tapusin natin ito. Okay. Darrell filed a complaint. Nulit ko pa. Number 1, is the request for admission deemed abandoned or withdrawn by the filing of the second amended complaint? Nung nag-file siya ng motion for partial judgment, bigla siya nag-amend ng complaint. Okay. Is the request for admission deemed abandoned? Filing of second amended complaint. So, ang tanong, etong amended complaint na to. Ano ba to si Darrell? Request for admission deemed abandoned or withdrawn. Wala, hulaan lang natin to. Yes. Letter B. If it substantially alters the cause of action, no. Can the fact subject of an answered request for admission be the basis of a summary judgment? So, hindi nag-request for admission, hindi nila sinagot. So, there was no specific denial, then it is deemed admitted. Question, can you use that for a basis of summary judgment? Yes. Teka, summary judgment. Ano nga ulit? Pag motion on the judgment on the pleadings, walang controversy. Kapag summary judgment, sham. Ito yung pinagmumukha na merong cause of action, merong dispute, pero wala naman. Hindi to sham. So, the fact subject of an answered request for admission. Ang basis ng summary judgment should be that there is no actual cause of action or that there is no actual controversy. No. Sige. Yes, no, no. Tingnan natin ang nangyari. No. The second amended complaint really supersedes the first amended complaint and nothing more. Pursuant to Rule 10, Section 8 of the Rules of Court, thus, the request for admission is not deemed abandoned or withdrawn by the filing of the second amended complaint. Okay. Ito, B. Mali ako. Such amendment could still be allowed when it is sought to serve the higher interest of substantial justice, prevent delay, and secure a just, speedy, and expensive disposition of actions and proceedings. The amended complaint may be allowed if it will not prejudice the rights of the parties. Letter C. Yes, summary judgment is a procedural device resorted to in order to avoid long drawn-out litigations and useless delays. Such judgment is generally based on the facts proven summarily by affidavits, depositions, pleadings, or admissions of the parties. In this case, the facts subject of an answered request are deemed admissions by the adverse party. Applying the Supreme Court's ruling in Spouses Vilyuga versus Kelly Hardware, these facts may be the basis of a summary judgment. Okay, 0 points tayo for today's video. Hindi mo na nga alam ng hula ka, mali pa din. Nahulaan ko yung lahat ng tamang maling sagot. Lahat ng maling sagot. Galing. Minsan talaga, hindi ka pagpapalayan sa hula mo. Kaya, dapat nag-aaral. Kasi dahil nadaanan ko ngayon to, malaki yung chance na hindi ko na siya kabasa huhulaan sa bar exams, di ba? Thank you very much. Naka 19 questions tayo in 2 hours. Kulang. Pero sige, break muna tayo for a bit. No? Timer. Pahinga tayo ng max ng 30 minutes ha. Okay. Sige, pahinga muna. Try kong bumalik sunan. Uh, yung Ubrin pala gamit ko dito, no? Okay. Sige nga, palitan natin ang road. Ano ba yun? So the moment nag-screen share ako, nagbago yung audio ko. Okay, sige. Mute ko muna to. And babalik ako in 30 minutes.
Okay, live na tayo ulit. Game. Convenient na meron akong Lawson na malapit dito. Game. Another 2 hours tayo guys. G. Okay. Let's go. Provisional remedies na naman. Ang tanong dito. Ayan, si Dory Enterprises. Dusyon and Pago. This is the action for nullification of the Danshon and Pago. Kaya check ko lang kung okay na rin ba yung video ko. Parang hindi pa nag-update sa YouTube. Okay na. Game na game. Okay, that's the action for nullification of the Dashon and Pago. Bar the filing of the interpleader case. Dory leased to Digna a parcel of land in Diliman. During the term of the lease, Digna... Teka, ilap muna tayo. Okay. During the term of the lease, Digna was informed by DBS Banking Corporation that it had acquired the lease property from the former owner Dory and required Digna to pay the rentals directly to it. Digna promptly informed Dory of DBS claim of ownership. Ulit, si Dory nagpalis kay Digna. Tapos, si Digna, in-inform siya ni DBS na nakuha na niya yung property from Dory. Now, pinagbabayad niya ngayon si Digna ng rentals sa kanya. Sabi naman ni Digna, Dory, sabi ni DBS, sa kanya na daw yung lot, sa kanya ako magbayad ng rent. Sabi na, in response, sabi ni Dory, hindi, ako pa din dapat ang bayaran mo ng lease kasi yung contract between us. So ngayon, dalawa si Dory at si DBS na naniningil kay Digna. Nag-file siya ng interpleader with the RTC of Manila. So Digna prayed na pwede bang bayad ko na lang sa court muna yung renta ko, tapos bahala na, pag na-discuss na, edi bigay mo sa kanila court. Okay. Tapos ngayon, later on, yung pala nangyari is the action for nullification of Dashen and Pago was filed by Dory against DBS. Yun man pala eh. Nalaman later on na si Dory, kino-contest niya pa rin yung ownership ni DBS. Sabi ni Dory, na sa kanilang dalawa, may better right pa rin siya sa rental payments. Sabi ni Dory, para ma-avoid yung conflicting decisions, the interpleader case must be dismissed. Okay. So ngayon, ang question, yung action dismissing the nullification of the Dashon and Pago bar the filing of the interpleader case.
Okay. Bar the filing. Anong pinag-uusapan dito? Res judicata, litis pendensya. O litis pendensya. O, sa litis pendensya. Ibig sabihin nito, pag litis pendensya, so ganoon pala, no? Pag civil to civil case, litis pendensya. Kapag civil to criminal case, prejudicial question. Galing, galing. Mas nagigets ko na siya. My answer. No. The action for interpleader shall not be barred. The nullification of the Sean and Pago under the law, under the rules, ordinary civil actions must be filed separately from special civil actions. Okay. Here, the nullification of the Sean and Pago is an ordinary civil action. The interpleader is a provisional remedy under special civil actions. Hence, there could be no bar as to the interpleader as the causes of action are separate and distinct. The causes of action for ordinary civil action is usually not the same for special civil actions. Okay. Check. 2.5 lang yun. Ano ba yun? Litis pendensya. Ito yung parang identity of the parties, identity of ra. Parang shit, di makalimutan ko yung mnemonic. Pero pareho lang. Parties, relief, outcome. O pag in-apply mo yun, is there litis pendensya in this case? There is identity of parties, but there is a difference in terms of the relief sought and the outcome. Okay? Identity of parties, at least such as represent the same interest in both actions. Identity of rights asserted and reliefs prayed for, the reliefs being founded in the same facts. The identity of case should be such that the judgment that may be rendered in one would, regardless of which party is successful, amount to res judicata in the other. Okay. Ano nga? Pero pareho. Outcome binding to the other. So parang outcome, identity of cause such that judgment in one would bind the other. Same rights asserted, same relief prayed for, same parties. Okay. So here there is no identity of parties. Yun pa lang sagot. The action for nullification, aray, so ito tumama, was filed by Dory against TBS. while interpleader was filed by Digna against Dory and DBS. There is also no identity of rights to certain reliefs prayed for. Nullification case sought to recover ownership over the leased properties, whereas the interpleader was filed by Digna to extinguish his obligation to pay rent. Since two requisites of litis pendentia are absent, the nullification of deed of the shown in payment case did not bar the file. Okay. Naisip naman natin yung litis pendentia. Yun na nga lang isagot natin lagi. Yung litis pendentia na yan. O at least, di ba? Nagbarar ako, hindi ko alam yung requisites ng latest pendensya, ng res judicata, ng double jeopardy. Wala akong enumeration na alam. Kapal din naman ng mukha ko mag-take ng bar exams last year. Last year. Oh well. Iba naman circumstances natin nun, guys. 8 minutes. Tagal. Spouses Don Don and Donna Dum Dum owned a residential lot in Dapitan City. Doy Dogonbot said a lot and took possession. Tagalogin na nga ulit natin. Mas madali pag tinatagalog ko yung mga tanong. Naiintindihan ko eh. Kumbaga pre-process na yung 2.5 lang haba ng tanong. What was it proper for the RTC of Dapitan to grant a motion for judgment on the pleadings? Ano ba requisites nun? Sige nga. Spouses Dondon, so yung mag-asawa, meron silang lot sa Dapitan. Si Doy, binili niya yung lot na yon, tapos nag-promise siyang magbayad ng 2 million within 6 months. After makakuha yung 500,000, so nag-exit na ng deed of absolute sale yung mag-asawa kay Doy. Tapos hindi binayaran ni Doy yung natirang balanse. So ngayon, yung spouses na nagbenta, nag-demand kay Doy na bayaran yung 1.5 na natitira plus interest na 150k. Si Doy, sabi niya, yung remaining balance admitted pero yung interest parang antas naman 10%. There being no payment, spouses Dumdum filed with the RTC of Dapitan a complaint for reconveyance with damages against Doy Dogan. Okay. Nag-file sila ng reconveyance para mabawi yung property plus damages. In his answer, sabi ni Doy, the purchase price had been fully paid, and for this reason, the complaint should have been dismissed. Okay. Spouses Dumdum then filed a motion for judgment on the pleadings, which was, kasi sham. Diba? Sham. Kapag judgment on the pleading, sham. Pag summary judgment, yun yung merong actual case or controversy, pero wala naman talagang, okay. The court awarded 1.5 million actual damages representing the balance of the purchase price, 200,000 as moral damages, and 200 exclamatory. Okay. Was it proper for the RTC of Dapitan to grant the motion for judgment on the pleadings? Yes. Yes, it was proper. Under the rules, judgment on the pleadings is proper when paano ko ba ibabanggitin yung sham? It's proper when the cause of action evidence presented by the defendant is a sham. Here, it was already established and admitted by Doy Dogan that he is indeed indebted for the balance of 1.5 million pesos. However, when he raised his affirmative defenses, saying the principal has been fully paid, the same constituted sham hence judgment on the pleadings proper. Mali daw. It's proper when the answer failed to tender an issue or otherwise admits the material allegations of the adverse parties pleading. So ang sham hindi pala summary judgment ang sham. Judgment of the pleadings, okay. He paid the purchase price in full. Okay, did not pay the balance of 1.5. He tendered an issue in his answer as to whether or not he has an outstanding paid balance with spouse's dumdum. The answer claims that the purchase price has been fully paid. Hence, kasi meron pang actual case or controversy. Kailangan ko talaga ma-distinguish yung dalawang yan. Hindi ko masyado naiintindihan yung magkukodal ako after nitong 500 questions ng REM. Sige, next. 5 minutes. Wow, we crossed the 100 mark. In 2015, In 2015, Dempsey purchased from Daria a parcel of land located in Dumaguete, Negros Oriental. The latter executed the deed of absolute sale and handed to Dempsey the owner's duplicate copy of TCT number 777 covering the property. Since he was working, Tagalog. What is Dempsey's remedy to have the reconstituted title in the name of Daria nullified? Okay. Si Dempsey bumili ng lupa kay Daria sa Dumaguete. So, si Daria nag-execute ng deed of sale at nabenta niya kay Dempsey. Okay. Nagkaroon ng TCT 777. So, ngayon, since nag-work si Dempsey sa Manila, and kailangan niyang bayaran yung taxes, registration and transfer costs, si Dempsey, iniwan niya sa possession niya yung TCT na hindi niya na-transfer to his name. Okay? A few years thereafter, nung meron na siyang pera, pumunta siya sa Register of Deeds at na-discover niya na after nung bentahan nila, nag-file si Daria ng petition for reconstitution of owner's duplicate copy of TCT 777. Nag-grant naman ng court. Ngayon, unknown to Dempsey, Daria was able to secure a new TCT in her name. Okay. Okay, gets. What is Dempsey's remedy to have the reconstituted title nullified? Ano ba pwede kong sagot dito? Hindi ko alam. Petition for annulment of judgment. Okay. Kasi nga naman, hindi niya alam. Pero it must be filed within 60 days nung nalaman niya yon, or within 6 months. Ano ba yun? Petition for annulment of judgment ba yun? The Supreme Court had consistently held that when the owner's duplicate certificate of title has not been lost, but is in fact in the possession of another person, then the reconstituted certificate is void. That the court rendered the decision had no jurisdiction. Reconstitution can validly be made only in case of loss of the original certificate. Petition for annulment. RTC Dumaguete had no jurisdiction to order the reconstitution of the owner's duplicate copy, considering that the owner's duplicate copy thereof had not been lost but is merely in Dempsey's possession. The order granting Daria's petition for reconstitution is therefore void. Accordingly, Dempsey may file a petition for annulment of judgment under Rule 47 to nullify the reconstituted title in Daria's name. Okay. Sige. So, dapat bago ma-reconstitute, dapat nawala talaga. Pero kung nabigay lang sa iba yung title, then hindi reconstitution ang proper remedy. Okay, so yan, Crim Pro tayo, Crim Pro. 357. Mas mabilis ako mag-review pag binabasa ko lang yung sagot. In a bypass operation, tanong, what was the challenge to the validity of the rest? Was the challenge timely raised? What is the remedy available to Daryl, if any, to be able to file an appeal? O, sige. Bypass operation, 30 kilos of shabu were seized from Dave and Daryl. They were arrested and placed on inquest before prosecutor Danilo. Teka lang. Okay. So 30 kilos of shabu were seized from Dave and Daryl. They were arrested and placed on inquest before prosecutor Danilo Doon, who ordered their continued detention. Thereafter, the information for the sale and distribution of shabu was filed in court. When arraigned, Dave and Daryl pleaded not guilty to the charge. During pre-trial, counsel for both of the accused raised for the first time the illegality of the arrest. Nasa pre-trial na sila eh. Wala, na-waive na yun. Hindi. Tanong, no. It was too late. Under the rules, the illegality of the arrest must be raised prior to arraignment. Failure to do so would be tantamount to a waiver of such illegality. To be able to file an appeal. Ano? Si Daryl. Dave and Daryl, okay. So si Dave lang at saka si Attorney Di Mayuga ang present. Si Daryl, wala. Okay. So anong remedy available kay Daryl? Okay. Daryl must file a motion mentioning the circumstances which prevented him from being present at the during promulgation of the case. Hindi ko alam kung tama yung sagot ko. motion to quash before he enters his plea of guilt. Otherwise, the objection is deemed waived. So from question of legality, surrender and file a motion for leave of court to file an appeal. Motion for leave of court to file an appeal, stating therein the reasons for his absence during the promulgation within 15 days from the date. Hindi pala motion for consideration. Motion for leave of court to file an appeal. The accused who fails to appear at the promulgation of the judgment of conviction shall lose the remedies available under the rules of court against the judgment, such as the filing of a motion for new trial or reconsideration, an appeal from the judgment of conviction. The rules of court, however, allow the accused to regain his standing in court to avail of these remedies by his surrender or and his filing of a motion for leave of court to avail of these remedies, stating therein the reasons for his absence within 15 days from the date of promulgation of judgment. Okay. Medyo malapit pero malayo pa. So, iskoran ko to. Tumama naman yung parang key answer, no? Yung concept, siguro mga 1 point. Max na 2. Yun na yun. Okay, next tayo. 6 minutes. Para makatapos ako ng 50 questions in 25 minutes, dapat 2 minutes each lang. Imposible talaga. So, dapat max 5 minutes na, no? Sige. Kailangan mabilis pa ako. Mas mabilis pa. Mabilis pa. Sige nga. Okay. Since in 2007, Court of Appeals, so na-appoint siya sa Supreme Court. Nung na-announce yung appointment, several groups kinwestiyon yung position niya. Hindi naman siya natural born citizen. Okay? Nung same year na yon, pinagbawalan siya na tanggapin yung appointment niya at mag-discharge ng functions hanggang makompleto niya yung requirements sa natural born citizen of the Philippines siya. Tapos, ginawa niya, nag-exercise siya as functions as Court of Appeals Justice. Pero dahil part yun ng qualification as CA Justice, si Attorney Dasho asked the OSG through a verified request na mag-co-warrant of proceeding against J. Dong. Sino ba si J. Dong? Si Justice. Si Dred Dong. Okay. Si Attorney Dasho, kinwestiyon niya si J. Dong. Na incumbent CA Justice siya. The OSG refused to initiate the action on the ground that the issue of J. Dong's citizenship was still being litigated in the under case. When the OSG refused to initiate a court warrant to, sabi ni Attorney Dasho, papile ako ng certiorari against the OSG and prohibition against J. Dong. So ngayon, nag-certiorari siya sa OSG na tapos sabi niya, hindi, dinidelay nila yung filing ko ng co-warrant to against Justice Dong. While the petition for certiorari and prohibition, okay. So, while the petition for certiorari and prohibition again, Dong asked the court to order him to cease and desist from further exercising his powers, duties, and responsibilities as CA Justice. In both instances, Attorney Dasho relied on the fact that at the time of J. Dong's appointment as CA Justice, his birth certificate indicated that he was Chinese. And his bar record showed that he was a naturalized Filipino citizen. Okay. So may the OSG be compelled in an action for certiorari to initiate a co-warrant of proceeding against J. Dong. Question, pwede ba yun? Ano ba to? Hindi ko alam. Sige na. Patingin, sagot. So no, the OSG has the discretion in determining presence of requisites for a co-warranto proceeding. Besides, there's already a pending case for the purpose of determining citizenship. Oh, yun na pala yun eh. So, hindi naman required ang OSG. If there is no right and it's a matter of discretion on the OSG, then there is no mandamus that can be filed against it. For a co-warranto proceeding to be successful, the private person suing must show a clear right to the contested office. Diba? Okay, in this case, since there is no original proceeding before J. Dong, where Attorney Dasho is a party, Attorney Dasho cannot be considered an aggrieved party for purposes of Rule 65. Wala siyang locus standi. So yun. So dapat si Attorney Dasho, meron siyang case na pina-file and nasa sala siya ni Justice Dong. Kung wala, hindi siya aggrieved. No? So hindi siya pwedeng mag-file ng Rule 65. At the same time, hindi niya pwede namang ding i-compel si OSG magko-warrant to. Anong case to? Anyway, natandaan ko na yung sagot. Alam ko yung mga suggested answer. Hindi naman absolute tong mga to. Take it with a grain of salt. Pero yun nga. Better na meron akong nabasang tanong at meron initial na suggested na sagot kaysa yung wala. Diba? Yung mas mahirap. Dodo was... 5 minutes. Dodo was not unconscious in a fist fight with Dindo. He was rushed to the emergency room of the medical city where he was examined and treated by Dr. Datu. As he was being examined, a plastic sachet appearing to contain shabu fell from Dodo's jacket, which was on a chair beside him. Dodo was thus arrested by the same policeman who assisted him at the hospital. Okay, at Dodo's trial, the public prosecutor called Dr. Datu to the witness stand. When the public prosecutor asked Dr. Datu as to what he saw in the emergency room, Dodo's counsel objected, claiming doctor-patient privilege rule. Okay. Question. How would I rule on the objection? I would object. I would overrule such objection. Under the rules, evidence, doctor patient privilege can only be invoked for those circumstances where consultation was done and within the privilege would only extend up to the limits of their consultations. Here, what is being asked is not in relation to the consultation, but rather on the personal knowledge of Dr. O, Dr. Datu, as to what is happening in the hospital in general. Hence, such privilege rule cannot be invoked, and I would overrule on the objection. Okay. Which may have been acquired in such as patient and professional capacity to act Yan yung sagot ko. So medyo malapit naman. 5 points. 5 points. Simple lang naman. Straightforward yung mga sagutan ko, di ba? Pero parang okay naman. Next. Okay. Ilang minutes yun? That was 3 minutes 45. O diba, ang bilis natin magsagot. 3 minutes 45. Sipin mo yun. Denny is on tanong. Proposed testimony of admissibility of testimony. Denny is on trial for homicide. The prosecution calls Danilo a police officer who interviewed the victim. True. Shortly after the shooting. Danila's testimony is being offered by the prosecution for purposes of proving that Drew is now dead. Okay. While in the emergency room, Drew was posting his medical condition on Facebook and was liking the posts of his Facebook friends. Drew asked the nurse for water but was refused because he was bleeding, which subsequently angered Drew. And that before dying, Drew signed a statement in which he identified Denny as the shooter. Denny, okay, a police officer. Sino si Danila? Baka si Drew to, no? Danilo. Yung police officer. Okay. Patay na si Drew. At nung nandun siya sa emergency room, nagpo-post pa siya ng medical condition on Facebook and while liking the post of his Facebook friends. Tapos tinanong pa ni Drew na hingi siya ng water. So nagalit pa nga si Drew kasi nga hindi siya nabigyan tubig. Tapos bago siya mamatay, pumirma siya ng statement na sinabi niya, si Nene talaga yung pumatay sa akin. Okay, so hearsay testimony, no? Ito yung testimony on account of death. There must be teka. Yung pang-apat yung crucial that before dying, Drew signed a statement in which he identified Denny as the shooter. So yung 2, independently relevant statement. Yung 3, independently relevant statement. Drew is now dead. Ano yan? Hearsay yan. Kasi hindi siya independently relevant. You're proving Drew is now dead as a truth. So it cannot be taken. Tapos, yung 4, parang hindi siya admissible. No? Yung 1 at 4 hindi admissible. Yung 2 at 3, question, relevant din ba? Hindi rin relevant yun eh. No. The testimony of Danilo is not admissible. Under the rules, in order for testimony of a dying person be admitted, it must be shown that the statement was made at the brink of death. Oh, parang issue dito is yung brink of death eh. Doon tayo mag-focus. Here, Denny was even still posting on Facebook and asking even for water, showing that he is not contemplating that death is imminent. Additionally, a dying person most probably does not have time, be sure to prepare and sign a document identifying this killer. Hence, the testimony is not admissible. Independently relevant statement, they are intended to merely establish either the truth or falsity of Drew's statement. Hindi na ako tumama dyan sa independently relevant statement na yan. Hindi ko pa rin nagigets. Kailangan ko pag-aralan yan. So, evidence. Sige na nga, papakinggan ko yung mga evidence reviewer pa. Seven, 8. Excuse me po. Dave is on trial for sexual assault of Delhi, a law student who sidelines as a call center agent. Dave offers the testimony of Danny, who says that Dave is known in the community as a decent and discerning person. Prosecution presents a rebuttal witness, Dovi, who testifies that if Dave was reputed to be a good person, that reputation was a misperception because Dave had been previously convicted of homicide. Dovi's testimony. Sino ba si Dovi dito? Si Danny, sabi niya mabait. Si Dave. Pero si Dovi, sabi niya, mali yun. Kasi convicted na ng homicide yan si Dave before. Okay. Ano ba yung testimony ni Dovi? Character evidence. In criminal cases, character evidence is what? Inadmissible naman eh. It's an independently relevant statement. Hindi rin relevant. Yes, is admissible. Dito ako magkamali ata sa bar sa mga admissibility ng evidence. Character evidence.
Di ko alam. Though his testimony on Dave's previous conviction for homicide as evidence of his bad character does not refer to a moral trait involved in the offense charged, which is sexual assault. So, Rule 130 of the Rules of Court. Ah. Whew. Parang hindi gumagalaw yung screen ko. Oh, hindi nga gumagalaw ah. Nangyari. Hindi gumagalaw. Oh, nag-stuck siya. O yan, gumagalaw na ulit. O yun. Nangyari. O yan. Buti pala chinek ko. Huh? Mic test, mic test. Gusto ko, kahit malayo ako dito, naririnig niyo ako. Nakukuba yung likod ko eh. Masyadong malakas. Okay na 18.
Siguro dapat hati-hatiin ko yung aral ko ba? Hindi naman eh. Paano kapag full time na ako nag-aaral? Dapat 16 hours kaya ko i-sustain yung pag-aaral ko. Sige na, next na. Paano katagal na spend ko dun? 7 minutes. Kasama yung pag-inarte ko dun. O, Atty. Dalmasio. The Director of the National Bureau of Investigation applied for a search warrant before the Executive Judge of RTC Manila. He alleged in his application that a certain alias, Django, was keeping about 10 kilos of shabu in a wooden cabinet located at Dillon Store in Paseo de Santa Rosa, Laguna. The Executive Judge of Manila personally examined Atty. Dalmasio and his witnesses and thereafter issued the search warrant, particularly describing the place to be searched and the items to be seized. Okay. Tanong is, pwede ba nag-issue? Certain alias Django. Paseo de Santa Rosa, Laguna. Hindi naman nagmamadali yan. So, dapat yung search warrant final sa RTC ng Laguna, ng Santa Rosa. Pero alam ko yung mga, ano ba yun? Regional trial courts. Yung mga special regional trial courts na pwede mag-issue ng search warrant across Metro Manila. Eh, Laguna, hindi naman Metro Manila yun eh. Okay, answer. No. The warrant must be filed in the RTC of Laguna. Letter B. Venue is jurisdictional. Yes. No. Yes. Piling ko yes, no to. Ay, yes, no nga. Okay. AM number 99-2009 of the Supreme Court states, all applications for search warrant personally endorsed by the head of the Philippine National Police, the National Bureau of Investigation, the Presidential Anti-Organized Crime Task Force, and the Reaction Against Crime Task Force, with the executive judge and vice executive judges of RTC, Manila, and Quezon City, may be served in places outside the territorial jurisdiction of said courts. In the case at bar, the application for the issuance of search was filed by the Director of National Bureau of Internal Revenue. So, head ng NBI, ng PNP, ng PAOK, TF, Presidential Anti-Organized Crime Task Force, and REACT TF, Reaction Against Crime Task Force. Okay. No, the legal concept of venue being jurisdictional is not applicable. The Supreme Court states that an application for a search warrant is a special criminal process rather than a criminal action. Hence, the legal concept of venue being jurisdictional is not applicable in case at bar. Okay? Bagong learning. Pampadagdag sa score natin sa bar exams, mga kababayan. Ano to? B. B. Okay. That was 4 minutes. Danjo. Danjo, a stay in gardener at the D family home. Si Danjo, saan yung Danjo? Sa Remedial. Ano to? Tanong, warrant of arrest issued against Danjo. Wala sa Philippines, valid. Yung warrant of arrest ba pwedeng be served on Danjo upon his return? Okay, yun yung dalawang tanong. So wala siya sa Pilipinas. Patay. Dito na ako sa limits ng aral ko. Kaya ko malagpasan tong antok na to. Let's see. Danjo, a stay-in gardener at the D family home in Quezon City, applied for overseas employment in Riyadh as a flower arranger. After he left for abroad, Dino D, head of the family, discovered that all his wristwatches were missing. Okay? Dino followed Danjo's Instagram account and in one instance saw Danjo wearing his Rolex watch. He filed a complaint for qualified theft against Danjo with the Office of the Prosecutor. Subpoena with the affidavit complaint was served on Denden, Danjo's wife, at their house. No counter affidavit was filed by Danjo, who continued to work in Riyadh. After conducting a preliminary investigation, the Office of the Prosecutor found probable cause against Danjo and subsequently filed the information for qualified theft before the RTC of Quezon City. The court likewise found probable cause and issued in 2016 a warrant for Danjo's arrest. Okay. Danjo was reported to the Philippines in 2018. While Danjo was lurking outside the D's house, which was only about 100 meters away from the police station, SPO1 Dodi recognized Danjo. Realizing that the police station had a copy of Danjo's warrant of arrest, SPO1 Dodi immediately pursued and arrested Danjo. Grabe naman yun. 2016 pa na issue yung warrant. 2018 na alala mo pa, SPO1. Pero ang sagot is, yes, the warrant of arrest oo nga na, paano ma-arrestuhin yun? Issued by against Danjo is valid. Under the rules, the issuance of a warrant of arrest is not barred by is not take into account where the offender, where the person to be arrested is currently residing or situated. Here, even though Danjo is abroad, a warrant of arrest may still be issued against him. Hence, the warrant of arrest is valid. B. No, the warrant of arrest cannot be issued upon his return. It is well settled under the rules. A warrant of arrest has a limited validity. Substantial time has already lapsed. From the issuance of the warrant. A new warrant of arrest must then be applied for. When Danjo returns. Ten days. Enough na daw na i-personally evaluate the prosecutor's report and supporting documents showing the existence of probable cause. In-establish lahat ng sinabi. Wala naman. Basta, kung ano to, when the law does not distinguish, the court shall not distinguish. Hindi naman din distinguish ng court kung ano yung nasaan ba yung person to be arrested. Ang sabi lang, may probable cause. Yun lang. Pag may probable cause, issue warrant of arrest. Unlike a search warrant, which is valid only for warrant of arrest remains valid. Ganun ba yun? Search warrant pala yung sinasabi ko. Okay. Pwede pa rin pala. Okay. Mali ako doon. So, tama yung possible na 2.5, 2.5. Mabigyan ako ng 2.5. Masaya na tayo. Mabigyan tayo ng 3.5. Maganda na yun. That's a very good pointing na ulit. Ang haba ng sagot. Mahaba. Masyadong mahaba. Ayoko nang i-paraphrase. 7:23. Okay. Don Deles. Was sued together with Mayor Dante Dungo and Congressman Dal Dilim for malversation of public funds before the Office of the Ombudsman. Danny Din, a material witness of the complainant, Diego Domingo, was hired as an engineer by a construction company in Qatar and had to depart in 2 months. To perpetuate Danny Din's testimony, Diego Domingo applied for his conditional examination before the Sandigan Bayan. Conditional examination? Ano to? Hindi ko alam masagot. Pero pili ko, not granted. So, mali ako. Sasagot ako ng yes dun eh. The case is still under investigation before the Office of the Ombudsman. There is no trial of the case before the Sandigan Bayan. Yet, Rule 119 on the conditional examination of the witness of the prosecution is made before the court where the case is pending. Rule 119, Section 12 of the Rules of Court state that a conditional examination of witnesses for the prosecution may be applied for when a person is held to answer for an offense. In addition to this requirement, the applicant must show that the witness is sick or infirm to appear at the trial as directed by the order of the court or has to leave the Philippines with no definite date of returning thereto. He may be forthwith be conditionally examined before the judge or the court where the case is pending. But since wala pang case na pending, di ba? Wala pang case sa Sandigan Bayan eh. So, dapat siguro doon siya sa Office of the Ombudsman examination. Anyway, hindi ko rin alam kung tatama yung sagot na yun. Pero ito yung tandaan nating sagot. Hindi aare. Dapat meron ng pending case. Okay, nantok na ako. OMG! Ang bigat na ng mata ko. Lakasan kaya natin yung ilaw.
Be ready, guys. Liwanag. It's like raining. Buksan natin ang ilaw na to. Ayan, sobrang liwanag na. Magising ka, Carl. Yan, F4. Pwede ba yan, F4? O masyado na ba madilim yung F4? 3.5. F2.8. Parang okay, F2.8. Pero lakasan natin yung ilaw doon. Masyado maliwanag. Yan, pwede na yan. Pwede na to. Yan, titigan nyo ako ng liwanag. Araw pa ngayon, Carlo. Ako yung sarili mo na araw pa. Mag-aaral ka. Hindi tayo aangat dito na hindi ka nakatapos ng... Pwede bang 100? Kaya ba 100? 50. 50 muna. 50. Oras na ba? Shit, 4 AM na. May 9 AM pa akong meeting sa pro. Advertised. Sige, kaya yan. Ilaban. Oras ako tutulog if ever. Pag hindi ako natulog, patay na ako mamayang gabi. Pagkatapos ng work. Minsan lang tayo mamamatay. This is the only year I'll be dying every day. Kaya yan. Ilaban natin. Game. The Republic of the Philippines. Pero ang sakit na ng likod ko. Hinahabol ko tong mic na to. May tataas pa ba to? Ang sakit sa ano? Move kaya natin to. Lagay ko dito. Yan. Okay. Yan. Kahit malayo ako dito. Ayan. Okay. Game. Pagod. Kaya pa, Carl? Kaya pa? Kaya pa. Laban. Dapat sumusuko. The Republic of the Philippines filed a complaint with the Sandigan Bayan in connection with the sequestered assets and properties of demo companies and pleaded its officers and directors. Since the complaint did not include demo as defendant, the Sandigan Bayan issued a resolution where it ordered demo to be included. Okay. Thereafter, the Republic filed an amended complaint naming demo as additional defendant, which amendment was later admitted. Okay. Demo filed a motion for bill of particulars for the Republic to clarify certain matters in the complaint. The Sandigan Bayan immediately granted the motion. Upon submission of the bill of particulars by the Republic, Demo filed a motion to dismiss, arguing that the answers in the bill were indefinite and deficient responses to the question of what the alleged illegally acquired funds or properties of Demo were. The Sandigan Bayan dismissed the case. Was the Sandigan Bayan correct in dismissing the case? What was the rationale again of the dismissal of the case by the Sandigan Bayan? It's the bill of particulars is indefinite
and deficient responses to the question of what the alleged illegally acquired funds or properties of demo were. Ano bang requirement ba yun? Kung ano yung actual funds or properties? Bigat na mata ko. I'd say... Oo. Damages is material, di ba? Ano ba to? Anong kaso to? Sequestered assets of demo companies. Okay. Na-sequester yung properties. Di ko alam. No, the syndic combined is incorrect in dismissing the case. An action cannot be dismissed on the ground of vagueness or indefiniteness. So, and number letter B, under Rule 12, Section 5 of the Rules of Court, after notice of denial of his motion. Ba't ganun? Nagkape ako pero inantok ako lalo. Siguro yung sugar yung nagpapaantok sa akin dun. Tata, nag-ano na lang ako eh. Sting? Masakit sa tiyan yung sting eh. The moving party may file his responsive pleading within the period to which he was entitled at the time of filing his motion. Okay. Oh, na-deny yung motion for bill of particulars. Patuloy lang ang kaso. Yung balance nun, tama ba? Woo! 7 minutes. So si Drillvik, German. Si Dara, Pilipina. Kinasal sila sa Germany. Nung nag-fail yung marriage nila, nag-file siya ng nullity sa RTC. Si Drillvik naman, nag-file ng divorce decree sa Germany. Okay, now si Drillvik nag-motion to dismiss sa RTC. Kasi wala na daw jurisdiction yung RTC of Manila. Kasi meron naman ng divorce decree na dissolve yung marriage na kay Dara. Dara objected, saying that while she was not challenging the divorce decree, the case in the RTC still had to proceed for the purpose of determining the issue of the children's custody. Trilby counters that the issue had been disposed of in the divorce decree, thus constituting res judicata. Okay. So this is a family case. Punta tayo. Bakit naging nasa ano to? Bakit nasa rem to? Should Drillvik's motion to dismiss be granted? Definitely no. Pero sige. The marriage. Drillvik filed the motion to dismiss. A. No. 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 motion to dismiss shall not be granted. Under the rules, in order to recognize change in status of the Filipino spouse by virtue of the divorce decree obtained abroad by the foreign spouse. The divorce decree must be alleged and proved in the local courts. Pero to, Rule 108 na lang to, di ba? Ang sabi ni Drillvic, motion to dismiss mo na yan, may divorce na tayo, doon okay na. Pero sabi naman ni Dara, teka lang, kailangan ko pa rin malaman yung custody, pinaglalaban ko yung anak natin. Gusto kong makasama yung anak ko. Sa akin ang anak ko. Ganon sabi ni Dara. O tapos, is a foreign divorce decree between a foreign spouse and a Filipino spouse, uncontested by both parties, sufficient by itself to cancel the entry in the civil registry. No! Same answers, sa taas. Copy natin to. Basically, copy-paste lang natin to. Paste. No. The divorce decree cannot sole basis. Ano ba ex parte? Ano ba ex parte? Hindi pala. Cannot be given effectivity in the Philippines by by itself. Ano ibig sabihin nun? Per se. Ayan. Tapos, motion to dismiss on the ground that the court no longer had jurisdiction of the matter as a decree. Failure to do so would divorce decree would not produce any effect. Pero motion to dismiss. Oo nga naman, dapat hindi siya mag-nullity. Anong motion para sa custody? Sige na nga. Kunyari yan yung sagot ko Copy-paste lang ako. Okay. But the legal effects thereof, custody, care, and support of the children must still be determined by our courts. Before our courts can give the effect of res judicata to a foreign judgment, such as the award of custody of the children, it must be shown that the parties opposed to the judgment had been given ample opportunity to do so on grounds allowed under Rule 39, Section 50 of the Rules of Court. Rule 39, Section 50 states that ang haba. Yan. An action in personam, a foreign judgment merely constitutes prima facie evidence of the justness of the claim of a party and as such is subject to proof to the contrary. Okay. So yung decree is just prima facie evidence. It must be proven. Uh, and Dara was given the opportunity to challenge the judgment of the German court, so that there is basis for declaring that the judgment as res judicata with regards to the rights of petition to have parental custody of their children. No. Pares lang yung sagot eh. 'Di ba? Pwede na sigurong 5 points. Pagod na ako. Pagod. Kapagod? We have to do what needs to be done. We do not stop. A in row here. Rule 39. Tapos in this case, tapos 2 children. Parang ang bibigat ng mga tanong nitong lately. 9 minutes. Ang bagal ko masyado magsagot. Ito na naman. Spec Pro na naman po tayo mga kababayan. Maikli ang tanong. Salamat po kaibigan. Kaso pag maikli ang tanong, tas hindi ko naman alam masagot, ganun din ang suma. Hindi mo rin masagutan. Delton, husband of Dakota, together with their 5 children, opposed the appointment of Dominic, claiming that Dominic was just a stepbrother of Dakota. After giving Dominic the chance to comment, the court issued an order affirming the appointment of Dominic. Si Dominic ang naging special administrator ng estate ni Dakota. Si Delton, husband ni Dakota, kasama niyang 5 children niya, sabi nila, bakit si Dominic, ang maging special administrator, stepbrother lang siya ni Dakota. The court issued an order affirming the appointment of Dominic. Malay ko anong remedy ng oppositors. Yung 5 children at saka ni Delton, hindi ko alam gagawin nila. Anong gagawin nyo? Sige nga. The remedy available to the oppositors as special administrator is to file a petition for certiorari. Okay. Certiorari na. Final na pala yun. Wala nang appeal, no? And maybe said through a petition for certiorari. Interlocutory pa lang appointment ng special administrator. Okay. If there are no qualified heirs, can the government initiate escheat proceedings over the assets of the deceased? To whom, in particular, should the estate of the deceased go, and for whose benefit? Usually kapag na-escheat, doon sa city or municipality kung saan nagre-reside yung decedent for the benefit of the residents of that municipality. Tingnan natin. The Solicitor General or his representatives in behalf of the Republic of the Philippines may file a petition with the Regional Trial Court where the deceased last, if he resided outside the Philippines, setting forth the facts and praying that the estate of the deceased be declared escheated. Once a judgment has been rendered in escheat proceedings, the properties of the deceased shall be assigned as follows. Personal estate to the municipality or city where he last resided. Okay. Real estate to the municipalities or cities in which the same is located. Okay. And if the deceased never resided in the Philippines, the whole estate may be assigned to the respective municipalities or cities where the same is located. Okay. Oh, pag resident siya, ang distinction, pag resident ka, personal property, kung saan ka nag-reside. Real estate property, kung saan nandun. Pero kapag non-resident ka, yung buong yon, kung nasaan yung mga properties na yon. And for the benefit of public schools, public charitable institutions, and centers in said municipalities or cities. Okay? So, yun lang hindi ko na yung public school, public charitable institutions, at saka centers in said municipal cities. Okay? A, B, siguro meron ako mga 3 points dun. Okay, next. Okay, 424. Whew. 108 to 120. Sa tigil ako ng 150. 30 na lang. May time pa ba ako? 4 o'clock na eh. 4 hours na ako nag-aaral. Minus 30 minutes. 3 and a half. Tapusin ko lang tong Pomodoro na to. Kailangan ko lang tapusin yung forest. Pag natapos ko tong forest na to, medyo okay na ako dyan. No? 33 minutes na lang. Tapos titignan ko, try ko magpahinga. Kung kaya ko pa, mag-iisa pa ako 2 hours. 2 hours Pomodoro natin, guys. Tapos pahinga lang ng 30 minutes. The municipality of Danao, Cebu was quiet and peaceful town until a group of miners from Denmark visited the area and discovered that it was rich in nickel. In partnership with the municipal mayor, the Danish miners had to flatten 10 acres of forest land by cutting all the trees before starting their mining operations. The local DNR, together with the Samahan Laban sa Sumisira sa Kalikasan, filed a petition for writ of kalikasan against the municipal mayor and the Danish miners in the RTC of Cebu. It is a petition within the jurisdiction of the RTC of Cebu. Ano ba? Rate of kalikasan, hindi ko naman kasi alam kung saan pinafile to eh. Nung dinidiscuss kasi ito ni attorney, pagod na ako. Pagod talaga ako dito sa mga special civil action na to. Ulitin ko nga yun. Hindi ko na-gets pala talaga yun. Ano ba? Titig lang yata ako sa reviewer nung time na yun. Sige, ano sagot? Hindi natin patagalin. Makatapos tayo ng madami. Rule 7, Section 3 of the Rules of Procedure for Environmental Cases provides that a petition for a writ of kalikasan is filed with the Supreme Court or any of the stations with the Court of Appeals. The precautionary principle states that when human activities may lead to threats of serious and irreversible damage to the environment, that is scientifically plausible but uncertain actions shall be taken to avoid or diminish that threat. Okay. Precautionary principle. Precaution. So, para siyang preventive suspension. Parang ganun. Let's go. Okay. Danica obtained a personal loan of 180,000 from Dingoy, payable in 18 equal monthly installments of 10,000 until fully paid. In order to complete her payment at an earlier date, Danica instead paid 20,000 monthly and continued doing so until the 15th month. Ulit, 180,000 tapos 18 equal monthly installment of 10K. So, para matapos ka agad, sabi niya, babayad ako ng 20K monthly. Tapos, nagbayad siya until the 15th month only. Pero tinanggap naman lahat ni Dinggoy. Later on, she realized that she had overpaid Dinggoy by 100% as she should have already completed payment in 9 months. So, tama naman. She demanded the return of the excess payment, but Dinggoy completely ignored her. Thus, Danica availed of the rules of procedure for small claims cases by filing before the municipal trial court a statement of claim together with the required documents. Okay, should the MTC proceed with the case under the revised rules on summary procedure, the rules of procedure for small claims, or the regular procedure? Kahinaan ko din yan eh. Alin ba dyan yung kailangan apply? Uh, Ba't di ko maalala kung alam ba yung dapat i-apply? Parang hindi ko rin naaral lang masyado yung rules of summary procedure at saka yung rule of procedure for small claims. Sige nga, sagot. Small claims. The MTC shall apply the revised rules in all actions which are purely civil in nature, where the claim or relief paid for is solely for payment or reimbursement of sum of money not exceeding 1 million pesos, exclusive of interest and costs. So, kapag prayer for sum of money, so 3 tiers pala yun. Ano ba to? Not exceeding 1. So, until 1 million, MTC under small claims, the rules of procedure for small claims. Pag 1,000,001 to 2 million, MTC, regular procedure. Kapag nag 2,000,001 onwards, RTC. Okay, gets? Having overpaid by 100% of the amount of the loan, Danica's claim for reimbursement amounts to 180,000 pesos, which is within the threshold of the revised rules. Thus, the MTC should proceed to hear and under the revised rules. Okay, sige. Okay, next. 642. What trial court outside Metro Manila has exclusive original jurisdiction over the following cases? Action filed on November 30, 2017 to recover the possession of an apartment unit being occupied by the defendant by mere tolerance of the plaintiff after the former peer ignored the last demand to vacate that was duly served upon and received by him on July 6, 2016. Ano ba to? Kailan ba yung revised rules? 2019 pa yun, di ba? So, ito, lumang case to. Exclusive original jurisdiction. Hindi ko naman alam kasi yung revise lang alam ko kapag ejectment case, MTC, Matic. Hindi ko naman alam yung luma. Ano ba? Nag-law school ba ako? Hindi ko alam yung luma. 2016 ako nag-start mag-law. Dapat alam ko to. Anyway. Okay. Complaint in which the principal relief sought is the enforcement of a seller's contractual right to repurchase a lot with an assessed value of 15,000 pesos. MTC? Letter A, MTC yan. Letter B is the enforcement of seller's contractual right to repurchase a lot. Personal action. Personal action, regular case. Assess value ng lot is 15,000. Hindi, ano to, MTC to. Summary judgment to, MTC. MTC din to. May METC ba? Hindi ko sure. Okay, BP 1 to 9. Okay. So, current pa rin pala. Does not exceed 400,000. Hindi ko na-gets. Yung utak ko sumsuko na. Supreme Court has held that where the ultimate relief sought by an action is the assertion of title to real property, the action is a real one and not one incapable of pecuniary estimation. Oh, yun. Ano ba yung 400,000 na yun? Akala ko ba pag ejectment matic yun regardless of the price? Ito ba yung before? Sige. Okay. Ano yung passing rate sa amin? Mas mataas sa best bar ever. Pagod niyo. Santa filed against ERA in the RTC of Quezon City an action for specific performance praying for the delivery of a parcel of land subject of their contract of sale. Unknown to the parties, the case was inadvertently raffled to an RTC designated as Special Commercial Court. Later, the RTC rendered judgment adverse to ERA, who, upon realizing that the trial court was not a regular RTC, approaches you and wants you to file a petition to have the judgment annulled for lack of jurisdiction. Si Santa, kinasuhan si ERA, specific performance. Narapol siya sa RTC designated as a Special Commercial Court. So basically, ang question dito is, pwede bang mag-render ng judgment yung RTC designated as Special Commercial Court for a case that is not a commercial case but rather a regular case? The answer is yes. Ay, anong yes? What advice? Hi ERA, we cannot we cannot do that. The RTC, even though designated as a special commercial court, may still take cognizance of regular cases. Hence, RTC had valid jurisdiction over your case. ERA, we cannot do that. ERA, we cannot do that. Ano ba? Ito si ERA. Ang tanong mo, 10,000 yun ha. Ay, naku, ERA. Sana ganito lang yung mga tanong sa bar, no? Or, ewan ko. Ay, sheesh. Saan ako natapos? So, 108 na ba ako? Andito na ako eh. Somewhere dito.
Nasaan na? Ito si Era. So, Remedial 3, 2017. Answer the following briefly. Daming tanong. Daming tanong, mga kababayan. Sobrang daming tanong. B. C. D. Oh. A. Hindi ko alam. The body of the crime is not present. Cannot be found. No witnesses. Or B. Kapag hindi siya matter of a right, matter of judicial discretion siya. So, ibig sabihin, kung matter of a right siya before and after conviction sa MTC, tapos matter of a right siya before conviction sa RTC, then it is now a matter of judicial discretion pag na-convict ka na sa RTC. Bail is a matter of judicial discretion upon conviction in the RTC or the CA. Give at least 2 instances when a piece of law may be a valid warrantless arrest. 2 instances. In flagrante, delicto, and hot pursuit. D. What is a tender of excluded evidence? This is the act of asking the court to incorporate in the court records as to incorporate the excluded evidence as part of the court records for consideration of the court, appellate court. Yun. Okay yan. There's more than one circumstance. The facts are from which the inferences are derived are proven. Hirap naman. Pwede ba akong gawan ng ano nito? Oh, sige nga. Good morning, morning. Many proven clues convict. More than one circumstance must exist. Proven. The facts from which the inferences are drawn must be established. Okay. Clues convict. The combined circumstances must lead to guilt beyond reasonable doubt. To rely on circumstantial proof, gather many proven clues that convict. Oh! Many proven clues. There must be more than one circumstantial evidence. Many proven. The facts by which the inferences are made must be established or proven. And many proven clues that convict. So, the circumstances, the combined circumstances must lead to guilt beyond reasonable doubt. Okay? Sige. Kailan? Before conviction by the RTC of an offense punishable by death. Matter of a right siya sa
before and after the MTC. Tapos, okay. Hindi, meron itong pinagkaiba eh. Kapag in the exercise of appellate jurisdiction ng RTC versus ng exclusive original jurisdiction. Whew. Sige. Pero tandaan na lang natin ito. Before conviction by the RTC of an offense punishable by death. So after conviction by the RTC of an offense not punishable by death. So before and after sa MTC level, it's a matter of a right. Before conviction sa RTC, where the evidence of guilt is not strong for capital punishments, that is still a right. Pero kapag may evidence of guilt is strong, then it's discretion. Pero after ng conviction sa RTC, hindi na siya available. Pero after ng conviction sa RTC, pero hindi capital offense, pwede ba makukuha ng decision tree nito? Ang hirap naman. OMG. Oh. Oh, ito ha. When in his presence, actually committing or not attempting to commit offense has just been committed, he has probable cause to believe based on personal knowledge of facts. Ang haba ng hard pursuit nito. When the person to be arrested is an escaped prisoner. Oh, yan. Letter D. Tender is the remedy of a party when the evidence is otherwise excluded by the court. If documentary or object evidence is excluded by the court, the offerer may have the same attached or made part of the record. If the evidence excluded is oral, the offerer may state for the record the name and other personal circumstances of the witness and the substance of the proposed testimony. Ayun. So parang hindi siya na-consider ng court nung nag-decide siya, pero at the same time, pinapasama niya pa rin. Kasi paano nga naman pag nag-appeal, hindi na mo consider on appeal. Malay mo kung kukusinin mo yung jurisdiction ng court, ko hindi mo na mo consider yon sa appellate court kasi nga na-exclude na yung evidence. So, dapat ganun siya. Okay? Sige. Ay, copy-paste muna ng sagot, mga kababayan. Kaya pa. Naitawid ko na yung antok ko. Gising na ulit ako. Gising na ako. Mga kababayan. Gising na ang kababayan. Shit. Nine minutes. Tinik natin. Masyado matagal. Brief answers. This doctrine provides that in the case of the exercise of the court's concurrent jurisdiction, the case must be filed with the lower court.
uh, the harmless error rule. Pumalay ko, ano yan? Hindi ko alam. When warrantless arrest is um, okay. Aba, ang professional ng sagot. Ito na ako eh. 2% na ba to? Worthy ba to ng 2 points? Hindi ko alam. The appellate court should not reverse a judgment as a result of any error or defect which does not affect the substantial rights of the parties. Okay. May ganun pala. Under the rules of criminal procedure, the lawfully arrested with warrant. Pero involving an offense which requires a preliminary investigation. So, meron pa palang offenses requiring preliminary investigation, no? Hindi natin alam, no? 2 minutes, very good. Kaya ko pa atang umisang 2 hours. 4:43. Kaya pa ba? Kaya! Kaya pa! Kakayanin. ABC Bank. Oh, 8 minutes na lang. Matatapos na yung Pomodoro ko. Ang bilis ah. Kung kailan na-overcome ko na yung antok ko. Ang helpful ng Pomodoro. Nilalaban ko talaga yung 2 hours eh, no? ABC Bank, sige, tanong. After working for 25 years in the Middle East, Evan returned to the Philippines to retire in Manila, the place of his birth and childhood. 10 years before his retirement, he bought for cash in his name a house and lot in Malate, Manila. 6 months after his return, he learned that his house and lot were the subject of foreclosure proceedings commenced by ABC Bank on the basis of a promissory note and deed of real estate mortgage he had allegedly executed in favor of ABC Bank 5 years earlier. Knowing that he was not the country, Evan forthwith initiated a complaint to RTC of Manila, praying that the subject documents be declared null and void. ABC Bank filed a motion to dismiss Evan's complaint on the ground of proper venue on the basis of stipulation in both documents designating Quezon City. Parang natanong na to dun sa kanina dun sa mga question 1 to 10. Natanong na to. Inulit na lang. Sige, gusto ko yung mga ganyan na ulit na tanong. Ibig sabihin yan, natandaan natin. Sagot tayo. Should the motion to dismiss of ABC Bank be granted? Iba lang yung pagkakatanong. So, motion to dismiss, ano bang basis ng motion to dismiss ng ABC Bank? Ang ground is improper venue on the basis of stipulation in both documents. Okay? So now, question. Question is there an improper venue? Saan ba nakatie up yung improper venue? Doon daw sa stipulation in the documents. Now, the next question would be, is that stipulation in the document valid? And for you to rule on that, is the document valid in itself? If you are now questioning the validity of the document, hence you will not apply the stipulation, instead invalid document supposedly. Okay, my answer, no. The motion to dismiss shall not be granted as ruled by the Supreme Court. When the validity of the contract itself is being assailed, the stipulation as to venue therein is to be set aside. And the general rules on venue under the rules on civil procedure shall govern. Here, Evan is assailing the very validity of the real estate mortgage supposedly executed by him. Therefore, it follows then that the stipulation in the contract, the venue stipulation in the contract, will be disregarded. Tagay natin set aside, disregarded. Since this case is, so ano ngayon yung subject documents be declared null and void. This is now turned to ito yung parehas ang property at residence, tama ba? So yung house nasa Malate, Manila. Tapos yung place of his birth and childhood sa Manila din. Oh, so ibig sabihin nasa Manila regardless. Sa RTC of Manila ka talaga magpa-file. Since his residence and the property both are within Manila, the proper venue then should be Manila, regardless of whether this case is one for personal, is an action in personam, or an action in rem. In rem. Therefore, the motion to dismiss of ABC Bank based on the ground of proper venue shall not be granted. Okay. Sige. Copy-paste natin yung sagot. And okay na ako doon. 5 points yun. Kapal na mukha. 7 minutes. 1 minute 40 second. Sige. Habol natin. Ana. A resident of Manila filed a complaint for the petition of a large tract of land located in Oriental Mindoro. She pleaded her brothers John and Adrian as defendants but did not plead Laika and Agatha, her two sisters who were permanent residents of Australia, arguing that there would be no final determination of the case without pleading all indispensable parties. John and Adrian moved to dismiss the complaint. The question now is, the court have a reason to deny the motion. Okay. Ano ba yung motion? Nag-motion to dismiss. Kasi bakit? Hindi implemented lahat ng parties. No. Paulit-ulit na tanong na to. Nasasanay na ako No. The trial court. No. Trial court doesn't have a reason. Deny a motion. Yes pala. Yes. The trial court has a reason to deny such motion. Minsan misleading na lang Under the rules, the failure to implead indispensable parties may be cured
by the subsequent pleading of such parties motu proprio or by motion of the parties. It is not a proper ground to dismiss a case. Here, the failure to implead the Laika and Agatha being indispensable parties to the case may be cured through an order of the court to implead them. Hence, the court has a reason to deny such motion. Okay. Ano ba? Pag mahaba yung sagot ko, ang ikli lang nung sagot nyo. Nagreklamo. Tapos na. Natapos na ang ating 2 hours. Pahinga ulit tayo ng 30 minutes. Ay, teka lang guys. Check ko po na ang aking pulso kung kaya ko pa. Yoko na. For now, okay na muna yun. Wala. Gusto ko lang mag-relax naman. Naka 4 hours tayo today. Meron pa ako mamayang meeting. Tapos meron pa ako maghapong trabaho. Tapos pagbalik ko dito, mag-aaral na naman ako mamaya. So, relax naman tayo ng konti, no? Marami naman tayo na-accomplish for today's video. Nakatapos tayo ng 40 questions. Reasonable na ba? For the time spent, we spent almost 5 hours for 40 questions. Ilang minutes yun? 5 hours. 5 times 60 is 300 divided by 40. 7.5 minutes on average. Pwede na. Teka, meron pa akong pahingang 39 minutes. Ibawas mo yung 40 minutes na yun. So, let's say 4 hours lang yung review ko, no? 4 hours multiplied by 60 minutes to 40 divided by 40. 6 minutes per question on average. Pwede na yun. Dahil ang sabi ni Legal Edge, kailangan mo i-target 7 minutes na pagsagot per question. Wala pa nga dun yung analysis nung sagot mo kung tama ba for the rechecking. So, yep, good enough pero kailangan pa rin improve. No, kailangan mas mabilis tayo makuha natin yung mga sagot. So guys, thank you so much for joining me again today. Join me again either tonight or tomorrow. See you on my next video.